Yes.
I know your lordship's view, my lord, under the compelling circumstances, this is upon notice. If your lordship directs me that to mention next month, but I will. But problem is this, my lord, that I filed an application entire praying for demarcation in the sense that entire property was acquired. A portion of the property, my lord, compensation has been paid, and there is an order by the competent authority to de-requisition or notify but that has not been done. In spite of that, my lord, they are going to demarcate the thing. They are going to recording their name in entirety. So that's why I came up before your
The
lordship.
court cannot stop recording.
No, that's why, my lord, if your lordship say that demarcate the property, my lord, that will suffice my purpose.
After some time, Mr. Pan, you are aware I'm not taking up
I
matters.
know, my lord. So
Please come back after I return.
after your lordship.
My lord, owing to extreme urgency, my lord, I am mentioning the matter. Kindly,
Do not mention any matter. Please do not embarrass the court. Only corrections, restorations, contempt applications.
Lord,
Please give me some time, please.
Lord, may I be permitted to mention, my lord, to move this application? My lord, it is very urgent matter, my lord. Urgency is this, my lord. The petitioner purchased a land with, my lord, dilapidated two-story building. And, my lord, we stand just by the, my lord, highway. My lord, Tomluk, Mecheda. And, my lord, Panchayat is every day. My lord, asks to the to my client.
Panchayat matters cannot be dealt with.
No,
by
my lord,
this
it is
court.
not Panchayat matter.
You've just said
Panchayat asks the petitioner, my lord, to demolish the structure, otherwise, my lord, accident may take place.
Yes.
My lord, business is going on.
So please approach the
My
appropriate
lord,
forum.
what is the problem is this, my lord? My lord, the land is acquired 2 times. My lord, by 2 notification. And first notification, my lord, is my lord, reflect in the Mauja Noksha. And my lord, second, my lord, acquired land is not reflected in the Mauja Noksha. And therefore, the petitioner made various representations. They did not pay any hit to them. And my lord, if I, my lord, demolish the building, dilapidated building, my lord, I have to again, my lord, constructed the building. My lord, according to my possessions, I will, my lord, construct the building. And my lord, either today or tomorrow, they will say that no, you have encroached our land, you demolish it.
Since
My
the
lord,
Panchayat
money,
has
my
tried-
lord,
since the Panchayat has asked to demolish and your representation is pending before the Panchayat,
no,
this
my
court
lord,
doesn't have jurisdiction.
Panchayat asked me to demolish it.
Yes.
Because it is a dilapidated building,
So I
it
will
is a
not
market
give any
area.
direction to the Panchayat.
That accident may took place. My lord, they have not issued any notice. They only, my lord, request me. And my lord, I have to demolish it.
Please file and come back. There is no urgency.
My lord, kindly
I'm
make
sorry.
it, my lord, under the heading new motion, my lord.
Not at all. Please
lord,
file and come back.
My lord, then, my lord, it will take time, much time.
It's the bench dealing with Panchayat matters, not this bench.
It is not the Panchayat matter at all. It is PWD's land. Against the PWD's land.
Please file and come back. I will not give any preference, any precedence, any preference to this. Please file and come back. Yes,
kindly make it on the new motion, my lord.
No. Please come, file and come back. Let it appear in its usual course.
The restoration application, your lordship. Restoration application.
Upon notice.
I have already given.
Lordship, for release.
May I permit
release.
What?
Release.
Upon notice.
Yes.
My lord, may I permit
Please
to
mention
mention one restoration application?
Upon notice to the other side.
Release. I am permitted to mention one correction.
Upon notice.
For upgradation, my lord.
You are aware I'm not taking up matters.
Regarding removal of unauthorized.
You are aware I'm not taking up mentionings now. Yes, call the day's list, please.
May I have lordship I leave to mention one matter, my lord, with regard to item number, my lord,
Sir, you
803.
have no leave to mention. You are aware.
My lord,
I'm not
I am.
taking up
This is
mentionings now.
mentioned appearing at the top of the list.
Maybe you have to wait for some time. Yes, call the day's list, please. Release item number देवा से हमने दिए भी mention तो दिए भी था mention तो दिए भी yes
Well, I am appearing on behalf of petitioners. Item number 1, my lord. Correction of solemn order dated 20th March.
serve that side Mr. Bottom is appearing
No, my lord. Actually, correction of order dated 20th March 2024. Year will be 2021, but it is written as 2022, my lord.
এই যে এটা 22 হয়ে গেছে, এটা 21 হবে এটা। WPA 12926 of 2021.
It will be 21,
2021, my lord, it is written as
the
2022.
number of the,
Yes, number.
WPA though. Pencil लेंगे, हाँ, हाँ.
নম্বর আছে তো বলো
12926
হুম।
of 21. And what about the other number?
Other number is correct, my lord. WPA 15296 of 2021. It is correct, my lord. 12926 of 2021.
Inadvertent error has crept into the order passed on March 20, 2024. Paragraph in the said order, WPA 12926 of 2022 be read as WPA 12926 of 2021. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on March 20, 2024. Urgent certified website copy.
Grateful, my lord.
Next,
Jai Ram.
I will say, and for the petitioner, that the matter is appearing under the heading extension of interim order, but my lord, stay was granted in respect of not.
For the state respondent, my lord, led by Mr.
not
My lord,
yet-
interim order was there till 30th April, my lord.
But my lord is not sitting from next week. That is why I have mentioned the same upon notice to the other side.
let it be extended for a limited period
And my lord, kindly fix any date because my
for
lord,
hearing.
for hearing,
Yes,
my lord,
yes.
and
Yes, ma'am.
kindly fix a time, my lord, because my lord,
All hearings start from 3:30, so that is the time.
my lord, one thing may I submit, my
Heard learned counsels for the parties. Paragraph,
Extension.
let the matter appear under the heading Group 1 hearing on 15th May.
my lord. And
And the interim order granted earlier is extended till 15th June or until further orders, comma, whichever is earlier.
grateful, my lord. But
The summer vacation intervenes.
one thing may I submit, my lord. My lord, stay was granted, but my lord, the parties are extracting sand illegally, and in this regard, I have lodged a police complaint, my lord. That is the urgency, grave urgency, my lord.
They have fixed it on 15th May.
So, my lord, the lease had expired long ago, but in view of the interim order, he, my lord, is in possession.
ওটা রেখে দিন কয়েকটা
Let it be taken up on 15th.
Third, let companies come back
Grateful, my lord.
Grateful.
for correction. Inadvertent error has crept into the order passed on 19th March 2024. Paragraph in the said order, WPA 8594 of 2022 be read as WPA 8594 of 2023. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on 19th March 2024. Urgent certified website copy.
My lord, I'm for item number 4, man.
And
Was
before
this-
the number was wrongly recorded, I've done the necessary
A
correction.
cost title error, man.
Yes,
Oh.
the number of the petition was wrong.
Yes.
Item number 5, I'm for the petitioner, my lord. One, dark number is 376 instead of 360.
You sir,
Yes,
the-
my lord, it's happening. Kindly see the paragraph,
320 and 376. These are the numbers.
prayer B, my lord, page 12. Plot number 320 and 366, my lord.
366.
Yes. I have noticed, my lord, to the
No, in the prayer it is 322 and 366. But in the petition it is 320 and 366.
320, 366, my lord.
But where is the service?
Mr. Supratim Dhar.
None appears for the respondents despite service of notice. Paragraph, inadvertent error has crept into the order. Karakura heard learned counsel for the petition. Inadvertent error has crept into the order passed on April 2, 2024. Paragraph in the only at one place. It is only in one place. In the sixth paragraph of the order, comma, plot number 376 be read as plot number 366 has been recorded as 76. Read as plot number 366. 76 to 66. Sorry. Paragraph, the department is directed to incorporate necessary correction. None appears to I had just recorded none appears. The first line category. The department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on April 2, 2024. Urgent certified website.
Declare, please.
Next. Six.
My lord, I have served the other side. This for withdrawal of the matter
Your appeal.
I'm the state.
with a liberty to file afresh, my lord.
Why?
Afresh, my lord.
Why?
Afresh.
Yes. Why do you want?
Oh,
to
why, my lord? Because I have missed out on certain points. That's why. Which I
Yes.
Hold on.
The petitioner seeks to withdraw the writ petitioners seek to withdraw the writ petition on the ground of certain defects detected therein and seek further liberty to file a fresh writ petition on the same cause of action. Paragraph, in view of the above, comma, the writ petition being WPS as and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioners to file a fresh writ petition on the same cause of action. Paragraph, there shall however be no order as to costs as a certified website. Next.
grateful, my lord.
Item 7, my lord, I appear on behalf of the petitioner. Sign of forming the
Yes, what is the,
I heard, one minute, I have submitted your lordship.
you are for the alleged contemner?
Yes, this respondent, only respondent, got election against whom he already expired in the year 2019. While I can speak for a moment, but everything is not over.
Where is your affidavit of compliance?
No matter I'm
direction upon the district magistrate of the private party.
my lord, I can speak for a moment.
Direction
yes,
upon the
sir.
district magistrate,
But
for the
everything will
superintendent
require
of police,
Where
and
is
the
the
district
affidavit
engineer.
of compliance?
infractuous. Everything is has been infractuous.
Private
But he left the blood that
private respondent. I am for the alleged contempt. Perhaps my learned senior friend is appearing for the private respondent.
Why is the private respondent is not a party?
But in the writ petition, they are in the part. But the writ petition is pending. In the writ petition, the private respondent is there.
The petition is pending.
Yes, my there is the interim order, and I do not know under why the contempt application has been filed, my lord.
It is
What
fine.
contempt, my lord, the respondent has done, but I have not been able to understand from the copy of the contempt petition. My lord.
order is there.
There is an
Interim order
interim
passed
order
by the
to
honorable court.
NQ.
May I submit one thing here? Everything become infractuous. Because 19, in the year 19, private respondent allegation against whom he expired. 1920 order has been passed. Thereafter, several order has been passed. Committee order has been passed without substitution. Everything becomes infrastructure. Nothing is there. After 19, how order has been passed? Several orders.
The order passed on 23rd December 2020 is under contempt.
Yes.
What is the
In
order kindly see?
23rd December 2020, page 16. Relevant portions, my lord, kindly come. Page 17, second paragraph.
Yes, I've seen the order.
Considering the facts of the case, I find that the petitioner has made out a prima facie case to obtain an interim order. Accordingly, the respondent number 2, 3, and 4. But 2 is the district magistrate, 3 is the superintendent of police, and 4 is the district engineer, are directed to ensure that any portion of the aforementioned highway is not encroached by any person whatsoever until disposal of the writ petition.
But
Yes.
Direction is
like
there,
after
but
passing
their
of this, that
enforcement is there, it should be removed.
done by the any of
Where
the
is
parties.
your compliance, affidavit of
But
compliance?
there is no content, my lord. What complaints I shall file, my lord? Even then, my lord, we have, my lord, issued notice. This is a, my lord, PW land unauthorized encroachment on the PW land, my lord. We have issued notice under section 10(1). My lord, the private owner has failed to, my lord, comply. Thereafter, we have, my lord, issued 10(2) notice before the, my lord, SDO. This is my instruction.
State that and file an affidavit
Yes.
of compliance.
Well, I can
That
do,
is
my lord, but there is no
yes.
content. As such, no direction, my lord, to it.
What
Only, my
direction,
lord,
Lord? I
to
fail to
ensure-
understand, Lord. This is
only to
specific direction
ensure-
is there.
No, man, only
It
to
has to
ensure.
be carried out.
That no one should encroach. You
Yes.
say there is encroachment already.
Encourage prior to filing of this petition. That is
So
why we
please
have
state
come.
that and file an affidavit of compliance.
I have taken step on such since
Yes,
by way of filing
annex
every-
those notices and please file an affidavit of compliance.
Yes, I shall do.
So that we can deal with the writ petition.
Yes, ma'am.
I think that will deal with the writ petition also.
Yes, it
Yes.
itself can be disposed of,
thing
my
has
here
to-
and now.
Yes,
Please
yes.
come back with your affidavit.
Milord, we have to one thing, Milord.
I need to see those documents.
Yes.
But after this, Milord, he expired. And Milord,
It's expired.
the private respondent,
Private party, Lord, private party expired. His son was, আপনি বলেছেন, his son was encroached. Then, my lord, his son has handed over to somebody. But they are continuing the encroachment. It should be removed.
but keep liberty to add as a party, Milord, additional party. And I obtained the property from the son and wife of the deceased person. Not the Tarok.
Illegal encroachment should be removed.
Yes.
That is his main
Yes,
prayer
maybe.
in the writ petition,
Yes.
madam.
He
What is the
expired.
interim order?
What is the allegation against a private respondent?
Tarok Bishwas has
Yes,
expired. Do you
expired.
want to
Madam,
He
substitute?
says, but he says Tarok Biswas expired. But I took instruction yesterday over telephone. Yes, he has been expired.
Yes.
Now, what happened? His
Yes,
son
certificate.
was encroached. Now, when after the order has been passed, order was communicated to the authorities. He not left the place and somebody they have encroached.
19 expired.
Some persons are encroaching the land.
So shall I expunge his name?
No
Or do
substitution.
you want to substitute him?
No, nothing.
But,
Nothing substitution.
What steps do you want to take?
Yes, nothing.
but just yesterday I came to know. So
So
far that party is
What is-
concerned, that is the another issue. But so long order is there of the
The
honorable
writ-
court.
No. I have requested Mr. Bottabal to come back with an affidavit of compliance.
Yes, yes.
Annexing the notices under section 10.
Only the notices. No steps has been taken to remove. It should be removed.
You are aware of section 10? Can any
Notice-
step be taken to remove under 1 and 2? There has to be a section 3 hearing.
Yes, yes, yes.
Yes. So they are taking steps. That is substantial
yes.
compliance. Why
No,
do
no.
you make such
Yes,
submissions?
Lord, steps have been taken to carry out the order.
Yes.
Lord, initially since
So
2022.
they have to carry out the entire proceedings. They have
Yes,
to
yes.
exhaust the
Yes,
proceedings.
yes.
They cannot just go and remove
No,
them.
no. By in accordance with the law, my lord, it should be removed.
They are doing
This
it. That's why I've called. See,
They
this
are-
is that's why I've called for
Yes.
the report.
Look,
Please
we have-
come back with an affidavit of compliance, annex those
I
documents.
shall
with
file
you.
but there is no matter content, madam. This is my respectful submission.
Yeah.
madam.
Again.
Make that statement also in your report.
Yes.
May be permitted to add as a party, as a respondent diet. We obtained
If the petitioner doesn't think you are you are a necessary, and you have not filed any application,
No, just now, Milord, just
then the petitioner take necessary steps.
But his details should be given to me.
for substitution.
But his details should be given to me. I
I
shall.
obtained property
not
from the
pursuant to-
son and wife of the deceased person.
How did you obtain, sir?
By virtue of
The sum
settlement,
by virtue of
by virtue of settlement,
sale,
settlement.
by virtue of sale,
No,
Settlement.
by virtue of settlement of deed of settlement.
settlement.
Fine.
So PWD land can be settled in favor of
But
the others.
Government land, somebody can.
That is, but your substitution necessary.
You are not a necessary party at all. Let the petitioner take steps.
Encroachment, but illegal
You are not a necessary party at all.
encroachers.
Kindly direct the only executive engineer to file report FDO to compliance because they have implemented district magistrate SP they are not the relevant whereas
I cannot go beyond that.
executive
That is the order under contempt.
but no contempt is there
3 and 4.
no order has been violated
And no substitution is there.
only interim order no but to ensure no further encroachment
No, not that.
The executive engineer.
the executive engineer may file
Direction is upon 2, 3 and 4.
but there is no contempt no direction for after
You are
passing
repeating
of
your
this order.
submission, Mr. Bottover.
Not very
Please
unfortunate.
come back with an affidavit stating whatever you are saying now.
Yes.
Yes. And even the steps taken by the authority.
Yes.
So that the writ petition can be disposed of.
This one here and now also. I have received the written instruction. Instruction is
Since the contempt is pending, I cannot do that. Contempt order করুন. Learned counsel for the alleged contemners submits that that there were encroachments on the state highway
In front of the petitioner's flat.
prior to the order passed by this court on 23rd December 2020 and proceeding under section 10 of the West Bengal Highways Act 1964 has been initiated by the state authorities for removal of such encroachment. Stop. There is no violation / contempt on the part of the alleged contemners. Stop. Learned counsel seeks to use an affidavit in this regard on the adjourned date. Paragraph, let the matter appear under the same heading on April 18th.
the more time is required as the election is there. That is another.
15th May.
Yes.
File 15.
But his submission, I am disputing. He says that there is no contempt. This is the disputing law.
Let him come back with the report.
What do you mean?
So at the line korun, the submission made by the by the alleged contemners, submission made on behalf of the alleged contemners is denied and disputed
By the petition.
by the petitioner, applicant petitioner.
May I be permitted to additional party? May I be permitted to
You are not a party to the contempt application at all.
But we are enjoying the property. We are enjoying the property. We are
You are enjoying on encroached property.
and
So you cannot encroach.
no encroachment. Without the encroachment.
Enjoy until you are thrown out.
Unauthorized encroachment.
There are 4 trees also is there. My letter final application for removal of the trees also.
I am dealing with the contempt application. When I deal with the writ petition, I'll
Yes,
consider all that. And please take steps in the meantime. The substitution. Today it is only the contempt application, so it's already.
But substitution, my lord,
But
But not a party to the contempt application at all, sir. So you have no locus to get the submission today.
I shall,
Next matter.
but I shall file the substitution application to the writ petition, not in the
Yes,
contempt.
yes, yes.
For the petitioner, lords kindly come to my lord's order dated 5th of March.
My lord, death certificate by your lords kindly give death certificate.
Take copy. Yes.
Yes, Mr. Talukdar wanted to
Yes,
produce
yes.
documents.
My lord, I stand corrected, my lord. There was a communication gap. It is not that you can get without any extra cost. What I received instruction, my lord, may kindly.
copy একটা দিন।
এটা instruction. এবার একটু বলছে মজা। এতক্ষণ বলছে দেব না। At the time of registration, the additional amount, the stamp duty on additional amount will only be paid.
Well, on the oil
Because the-
directed him to produce the notification of 2005.
That's
That document.
That's true. But on the last occasion, my lord, I have,
File all those documents today
yes, I have brought all this.
by way of an affidavit. You have to serve copy to the petitioner.
There was,
He has to go through the documents.
no direction for affidavit. That
When you
is,
file documents, you cannot just file it, isn't it? It has to be supported by an affidavit.
then I have to,
And
I'll have-
you have to serve a copy to learned
Yes,
counsel. He has to go through the documents.
Or next week then,
Not next week. Next week, not possible.
everything was.
I thought, my lord, I have brought the copy, sufficient copy I have.
Please serve an advance copy so that he can go through it. We'll be ready on the
Then
next day. to
is-
that.
Instead of affidavit, can I supply the documents or?
You don't need to swear an affidavit to supply copy. It's only before the court that you have to swear an affidavit, isn't it? Copies can be supplied even without an affidavit.
So if I am to, my lord, swear an affidavit, then affidavit will be served on him,
You can take
annexing
this
all
back.
this, yes.
We later fill up with them.
My lord, I thought that, since there is
No, because it's the KMDA's documents. It has to be on record by way of an
very,
affidavit.
very, very.
Learned counsel for the KMDA seeks accommodation to produce relevant documents in support of his contentions by way of an affidavit. Paragraph, let the matter appear under the heading one motion on 13th May.
Under heading for orders.
Yes,
For orders.
let it appear.
Very well, under the same heading,
Yes.
under the same heading.
No further argument on merit, my lord, only I will, what I told, what I submitted on the earlier occasion, my lord, I shall.
And in the meantime, Mr. Talukdar will circulate the evidence.
Yes, yes.
Now, next matter, same mill.
Next matter, same order.
Same only.
Next matter, I appeal for the state matter.
Only to the petitioner, state.
Kashu, same order. Same order.
I am not a state.
The point involved in this petition, this is the fourth round of litigation. The point involved in this petition that a plot of
So
land,
they wanted to come back with a report in the form of an affidavit.
My lord, it is, he challenged the.
I think in the meantime, the government has already passed a notification recently in the March 2024. But here the crux of the issue is this: land was allotted, and an agreement was executed, offer and accepted, and the petitioner was liable to pay the lease rate.
Kolani.
Liable to pay the now from the records it appears that admitted fact that after he paid only two installments, so the remaining 4 installments are due since a long period of time. Number one, the land was forfeited. Amount which was deposited, that was also forfeited. Challenging that, a writ petition was moved before this honorable court. It was the first writ petition was disposed of by Honorable Justice Pranab Kumar Chattopadhyay when his lordship then was. Lordship will find page 82 onwards, the order, Lordship Pranab Chattopadhyay, the order. His lordship was pleased to direct them to assess the amount which were due to be paid. And the petitioner was directed to pay the said amount as assessed by the authority within a certain period of time. And if the payment is made, then the deed will be executed, the possession would be granted. Without challenging that order, the state preferred an appeal. Before the Honorable Division Bench, Lordship will find as page 86. The said appeal came up for hearing before the Honorable Division Bench of the then Honorable Chief Justice S.S. Teacher, sitting with Justice Pinaki Chandra Ghosh. Their Lordship was pleased to hold that since the learned single judge, that means the Justice Pranab Chattopadhyay did not specify in his Lordship's order, the matter remanded back to again to the learned single judge. And thereafter, the finally Lordship will find at page 90, the matter was decided by the Honorable Justice I.P. Mukherjee. Lordship will find at page 91. Honorable Justice I.P. Mukherjee was pleased to direct the authority concerned to reconsider the issue after giving an opportunity of hearing to the parties and in accordance with law and reasonable decisions should be taken. Now, thereafter, the authority concerned passed the impugned order at page 1996, annexure P11, which is challenged in this writ petition. Now, if your Lordship kindly take page 97.
Order, my lord. If your lordship will
That will Lordship, I'm coming.
This order, my lord.
Mr. I'm coming. Everything I will soon. My lord, kindly come page 97. Has your Lordship got page 97?
97, yes.
My lord, kindly see the matter has been examined in the light of, in the middle portion. The matter has been examined in the light of the aforesaid order of the Honorable High Court, extant government rules, orders, statutory laws, as well as available office order. This fact that a lease agreement for allotment of land was entered into on such and such date. The instant case is regarding plot number such and such of Fulton Township, which was allotted to the petitioner, Sri Swapan Kumar Seal, on 17/5/69. The possession of the said plot was not taken by the petitioner for non-fulfillment of the allotment order and condition. The due amount of salami was not paid within a prescribed period. As per clause 3 of the lease agreement dated 3rd April 1969, the petitioner has to pay 1/3 of the salami within 2 months of acceptance of the agreement, that is by 2/6/69, and the rest 2/3 of the salami in 6 equal installments beginning from 2/6/1970. But from the record, it transfers that he failed to pay 1/3 of the salami amount within the due date of 2/6/69. Balance 2/3 of the salami amount was also defaulted by him. The petitioner did not dispute these facts admitted in position in clause 3, the is stated inter alia. So these are the grounds they have taken to forfeit the agreement. My lord, now my lord, probably my learned friend knows this. On 7th March 2024, a notification has come, whereby the principles relating to regularization of the allotment of the land government considered. After payment of, my lord, if your lordship, I am handing over a copy. The allottee may be given an opportunity to pay the balance amount as the current market value to be assessed by the IGR. In such case, the lease deed may be executed and possession may be handed over of the following due process.
My lord, what is the use of this case, my lord?
This is the notification dated 7th March 2024. Let it be considered in the light of this notification.
And now they are coming to get that. They can.
The government has given the opportunity.
My lord, they can file an application before the authority, and authority will consider whether that aspect will consider or not. My lord, in this case, nothing is there, my lord.
My lord, now since this has come,
my lord,
this notification has come.
And there is many ambiguity in this order.
Was also in 2017, I think.
Lordship, and thereafter during the pendency.
That is 2024. 1969, my lord, they defaulted. And they are coming now. And wanted to, my lord, bypass all the things, my lord. That is not permissible in law, my lord.
For the last 20 years.
Retrospective effect, please show me.
Lordship.
I believe there was a direction for affidavits.
My lord, after going through the petition, my lord, and after taking, my lord, a consultation with my client, my lord, I have seen that that is very good order, my lord. There is an order. But that is, my lord, I may not want to file any affidavit, my lord.
Now the government, on the basis of this notification, has started to consider all such type of cases.
For that reason, he can file an application before the authority, my lord, not before the.
Then
order
Honorable
of
Lordship
High
kindly
Court.
grant me liberty. Grant me liberty in view of such notification. The petitioner should be directed to file, submit an application.
For this reason, my lord, liberty is not necessary, my lord.
Now, because the notification
File an
has come.
application, that
This
is
is the
his
Gazette
order.
notification. This is the law. This is the present law. You cannot deny this notification.
The petitioner wants to file an application, let him file an application before the authority and let them consider in terms of this.
In the light of this notification, Lordship.
Third learned counsels for the parties, paragraph. Is contended on behalf of the petitioner that plot in question was allotted in favor of the petitioner by the government of West Bengal on an application for lease made by the petitioner in 1968.
My lord, that application is not in any way, that was not, my lord, before your lordship, as because without the hand. My lord, that is handed over to your, that is not by an application or other things, my lord. So, my lord, your lordship can.
I'm recording the submission of the petitioner.
And that copy, my lord, should be with the briefs of this.
Copy of?
Copy of the which was handed over to my landed friend, my lord, before your lordship. That was be in the records, my lord.
Today's copy.
Well,
The notification.
yes, my lord.
This is your notification.
Whatever may be that, my lord. Today, my lord, he was handed over that.
Yes, I'll just record that.
Yes, my lord. Otherwise, my lord.
Copy of notification issued by the Department of Urban Development and Municipal Affairs, Government of West Bengal, dated 7th March 2024, submitted by the petitioner, is taken on record. তারপরে other copies for the parties. And agreement for lease and agreement for lease was executed on 7th December 1978. Since the petitioner was unable to comply with the terms and conditions of the lease agreement due to several reasons, a show cause notice was issued upon the petitioner as to why the lease agreement would not be terminated and the amount deposited be forfeited for failure of the petitioner to pay the entire amount of salami, SALAMI. The petitioner requested the respondent authorities to allow him to deposit the entire balance salami together with interest thereon, despite which the lease agreement was terminated on 30th July 1991. The petitioner approached this court by a writ petition against such termination order and by an order passed on 22nd April 2004 in CO 4876 within bracket W of 1992, a coordinate bench of this court set aside the termination order and directed the respondents to take necessary steps for execution of the deed of lease in favor of the petitioner within a stipulated time frame upon payment of outstanding dues by the petitioner. The order was carried in appeal by the state and by an order passed on 4th October 2007 in MAT 3264 of 2004, an honorable division bench of this court set aside the order of the learned single judge and remanded the matter back to the learned single judge for a decision on merits in accordance with law. Pursuant thereto, the matter was taken up by this court and by an order passed on 11th July 2017 in WP 4876 within bracket W of 1992, the court directed the Principal Secretary, Urban Development Department, Government of West Bengal to reconsider the decision of the government by exploring the possibility of validating the lease of 1969 in favor of the petitioner on such terms and conditions as he would think fit and proper, and upon giving a short hearing to the petitioner within a stipulated time frame. In compliance with the said order, the concerned authority, by the order impugned, turned down the prayer of the petitioner for reallotment of the land in his favor. The said order is impugned in the writ petition. Paragraph. Today, learned counsel for the petitioner produces a notification issued by the Department of Urban Development and Municipal Affairs, Government of West Bengal, on 7th March 2024, which deals with guiding principles relating to regularization of allotment of land. The petitioner seeks to submit a comprehensive representation before the concerned authority in this regard and prays for a direction upon the authority to consider the representation in the light of the notification dated 7th March 2024. Paragraph. In view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation before. Who should be the respondent, Mr. One. Yes, ma'am. Before the first respondent. Before the first respondent. Within 1 week?
That's
My lord, may I be permitted to only one line add. To my lord, I submit before your lordship that the order is written order. And just, there is no any ambiguity of this order. Only that line may be.
Learned counsel for the respondents submits. Submission reporting. Submits that the order impugned is a reasoned order and
And requires no interference. My lord. That is
and
my submission.
requires no intervention by this court.
My lord, then, my lord, I am also humbly submit. My lord, this observation shall not prevent. the petition-
Observation, submission.
Submission,
This
observation.
is his submission.
Submission, no observation.
Disposal with liberty to the petitioner to submit a comprehensive presentation before the first respondent within 7 days from date. Stop. The first respondent is directed to consider and dispose of the representation within 2 months.
Lordship.
Within 2 months from the date of receipt
My lord,
thereof.
till now, principal secretary is also very, my lord.
2 months.
Assistant president is the-
আসতো এই বললো যা আমাদের এখানে লাস্ট ইলেকশনটা হলো মুশকিল my lord
Upon
3 months.
according reasonable, not 3 months. Let it be 2
and
months.
because my lord there is
না, তাহলে
my lord election is first
Very 3 months. Kono.
এই
3
রেসপন্ডেন্ট
months actually
3 months.
তোমার একটা ব্যাপার বাবা
Upon affording reasonable opportunity of hearing to all concerned, including the petitioner,
opposition দিলেই তো অনেক
and in the light of the notification dated 7th March 2024, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of.
I am obliged to lose.
Next,
But that notification kept in record. Petitioner,
Item number 11, my lord.
and pursuant to lordship's direction,
In this matter,
My-
my lord.
state has already filed a report.
in
My
this-
lord, I am
in-
finding the exception.
In this matter, my lord, court amendment, this matter was dismissed for default. Then, my lord, the matter restored.
yes.
In the meantime, my lord, I handed over my brief.
So you need a fresh
And
copy.
no, they have supplied a fresh copy, but without annexure of the petition.
Without
Sir.
annexure.
Annexure to the petition. And though I am,
Please hand over the annexures also.
and my lord,
Kindly fix a date. In the meantime, I shall serve a complete set of writ petition along
and-
with the report, exception today's.
and my lord, one thing, my lord, they have used an affidavit in my report.
The exception, yes.
I may be permitted, if necessary, a short reply.
Reply to the exception. This
No,
is the
no,
exception.
they have filed affidavit in opposition.
No.
No.
With the, you
Oh,
have
yeah,
filed a
yeah,
report
yeah.
in the form of affidavit.
Affidavit in exception.
Filed a
All
report,
right, my
we
lord.
use an exception to it. You can make your submissions.
All right. Next week, my lord.
Not next week. Affidavit of exception submitted on behalf of the petitioner is taken on record. Paragraph on prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 16th May.
That's it.
Yes.
No, then, but-
Patil.
Next.
আপনার যদি
Annexure to the annex.
খালি annex এগুলো করে দিন।
হ্যাঁ, আজকে রাখবেন।
Obliged to lose.
Well, my lord, Mr. Bolalal Sahu is appearing.
While I am for the state,
He is,
my
my lord, out of station, my lord. I am praying for only not to them.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 16th May.
My lord, kindly, my lord, next week, any day in the
Not
next week.
possible. Next.
Madam, for the petitions. My lord, I am for the petitioner, my lord. My lord, in the last occasion, my lord, adjournment was sought, my lord, but they were supposed to seek instruction from the authorities that whether the elevator that is being constructed in front of the metro station
Pero আপনি আসেন।
shall be constructed inside the metro station or not. That should be the they were supposed to seek
Sir.
instruction, my lord.
Mr. Gupta is appearing for the.
I am
better.
You're there. Yes. The Metro Railway authorities are implemented.
Yes, my lord.
It's for them to answer, isn't it?
Yes, my lord.
Who is appearing for the authority?
My lord, Mr. Choyon Gupta, Mr. Shak.
For HITCO.
ওটা তো HITCO. No one appears. No one is appearing, man. The state, it is state.
You are the requiring body.
My lord.
And the construction is being made by you.
No, my lord. My lord, we have handed over the, my lord, the land to, my lord, the metro authorities, my lord. They are now making the construction, my lord.
Metro. For the metro railways.
My lord, metro was, my lord, earlier represented in this matter, my lord.
Yes, my lord.
My lord, they were earlier represented in this matter, my lord.
My lord,
No, no.
by an order on October 5th, 2023, my lord. In this order, your lordship was directed that it is made clear. My lord, have you got the order?
That will be taken up even in their absence.
Yes, yes, my
But
lord.
will it really help you? That's what I was wondering.
Exactly.
Respondent number 3, someone was appearing earlier. Mr. Shukanto Chakraborty. Who is he? He appears for the metro railways.
And Metro also filed a report in the form of affidavit.
I find
We have
one
filed
name
an
here, Mr.
exception.
Shukanto Chakraborty.
Yes.
Yes, my lord.
He had appeared and one day he had come and made submissions before him, my lord also. At that time, due to paucity of time, the hearing couldn't be concluded. And your lordship was pleased to keep it on some other.
But
Metro
after
is really the answering respondent. Their grievance is a metro station constructed in right in front of their shop,
yes,
which is affecting their business, and that
affecting.
should have been shifted.
Proposal for shifting the.
It was a proposal for
elevator,
shifting.
I think.
That is the only.
Yes.
Within the premises of the
Such a station has
That
already
is
been-
all this issue.
Now, possibly the station has been completed and the train is also run.
The
Possibly, I do
petitioners
not.
have no, the station, it's still left. Yes. The construction of the elevator or the staircase, which they were supposed to seek instruction is still.
With regard to item number 13, my lord, Mr. Shukanto Chakraborty, my lord, is appearing for Metro Railway. My lord, he is in some difficulty, he has not come to court. If your lordship, my lord, kindly takes it up any other day, my lord, he shall take instruction and come.
My lord, kindly keep it as a last chance, my lord, for them, because
It will be taken up, he's vanished.
But I shall intimate him. I shall intimate. Possibly Mr. Anindo Haldar is appearing.
Please request
I'll
him to
tell.
appear on the next date positively. Because on the earlier occasion, it was adjourned on your prayer.
yes,
Petition is-
yes, yes, ma'am.
So last chance can't be granted. Come back, please request him. On prayer of the
My lord,
metro
my
railways,
lord,
the
my
matter
lord, one
is-
indulgence, kindly direct them to seek instruction if the elevator can be constructed inside the station
That
or.
was discussed on the convocation so far as I can remember.
Yes, yes, my lord, but they were supposed to file the report on the
I'll
basis
record.
of that.
I'll record.
All right, ma'am.
On prayer of the metro railways, the matter is adjourned. Paragraph, let the matter appear under the same heading on 14th May. Paragraph, in the meantime, learned counsel for the metro railways is requested to take instructions as to whether the proposed elevator can be constructed within the premises of the the railway station. The metro railway station. Jayanto.
Outside
Lord.
the.
Elevator can be constructed within the metro railway station. Next. Okay.
This matter, your lordship would recollect after, I am for the petitioner.
Oh.
My lord, after filing the writ petition,
My learned friend to this case, I have been guided by my learned senior, my lord.
Yes.
after filing the writ petition, your lordship, my lord, directed the state to file reports. From the report, it transpired that the point taken by two of the respondent, two reports were filed. According to the report filed by the state respondents, it transpired, on the one hand, they say that in view of the gift being unconditional, there was no, my lord, consensus on the part of the state to give a job or employment in lieu of that gift deed. It is my client who gave his entire property to the state, and a public health center has been erected, investing, my lord, about 50 crores. The consensus was at that point of time, there was nobody, they invited all, that the one who would be giving the land for public health center, we will provide an employment to that. Now, the other affidavit report which has come on record, from that it appears that a point was taken by the respondent number 6, that in a case of acquisition, the scheme was there to give appointment. Because this affidavit was filed by the said respondent, that if there is an acquisition of a plot of land and there the scheme according to them prevailed to provide an employment, I came up with an application for amendment that apart from the subject property which has been gifted by my client, and a consensus was there to give employment where public health center has cropped up, created. Thereafter, the residue land which was there by with the predecessor, that was acquired by them. Annexing those documents, I filed exception to the report. Upon considering this report together with my affidavit and exception, your lordship directed me to approach the concerned respondent to ascertain whether, my lord, they have paid in lieu of that or not. We found, my lord, they have not paid, but that will be a separate dispute, whether in lieu of that acquisition.
On your prayer, you were granted liberty to approach the 6th respondent.
Yes, I went there.
Compensation.
Yes, I went there, my lord. From that, I ascertained that in lieu of the property which was acquired, my client has not got acquisition. But that is not the subject matter here. The subject matter is that according to them, in lieu of acquisition, apart from compensation or award money, one is entitled to employment. The case was based previously when I came before the writ court on the basis of gift deed alone. The gift deed, according to the petitioner's case, in view of the gift deed, they should provide an employment. They came with an objection that no, had there been acquisition, employment can be given. I came up with the record that there has been acquisition of part property. Therefore, on the basis of report as it stands, that in a case of acquisition, the scheme existed for providing employment, the writ petition was amended. And
you filed an amended report?
Yes, my lord, I have filed it. At this stage, I would pray before your lordship, let there be a direction to file affidavit in opposition against my amended writ petition, if they want to controvert it. Because these are all accepted facts. These are all on record which I have submitted. That will be evident from the report filed by 2 of the respondents. In view of that, your lordship directed that because there has been change taking place in the proceeding, I should file a amended writ petition, and accordingly I filed the writ petition. Therefore, let the state respondents file an short affidavit dealing with my affidavit, and it may be heard any day.
It's required at all. Yes, Mr. Guchai?
Because one affidavit is required, because I am not supporting my learned friend's submission. Because he is saying one hand that we have gifted the property. Another hand, he is saying that our land has been as per
Two parts.
Another 2 parts. Another part is saying
one part is gifted, another part is acquired.
From our record, apart from deed of gift, we have acquired them. That is his version.
Yes, yes, correct.
But we have, the record. We have shown to your lordship that only section 3 notice was issued upon my learned friends for requisition, not acquisition. And also we have submitted the report to your lordship, wherein we have categorically stated that whatever the land we have acquired apart from the land gifted by the learned client, that entire compensation has been paid to the person from whom we have acquired. That's why there was no question of any acquisition of the land from the petitioner's part, from the client of the my learned friend. Only another part is that we have got the land from my landed client by a deed of gift. Deed of gift, your lordship knows, there is no condition, and there is no condition that money that my lord, the said my lord descendant would be named.
The acquisition part, you say that it was taken, it was acquired from some other person.
Other person, and land compensation has been paid.
Come
And
back on
that awards
affidavits.
here, that awards here also has
Let's come back on affidavits in
my lord, he is not, and regarding my lord, appointment part, but our labor departments, my lord, circular came into effect for giving an appointment to the persons who has land has been acquired by the government, being treated as the landlord. That is in the year 2002. At the material point of time, there is no such scheme. There are no such scheme. Scheme cannot be, my lord, by retrospective effect. That could be always my lord, prospective effect. That's why, my lord, I want to file the, my lord, the evidence in opposition.
My lord, your lordship, I am not, my lord, adding anything. ঠিক আছে, কোনো অসুবিধা নেই. Just I would indicate, my learned friend says that they have not acquired. The fact that they have acquired, I have filed all document in the exception
They do
itself.
not say that they have not acquired. They say they have acquired not from you.
No, that can be taken note of from my exception itself. Where, yes, let them file opposition. Because it bears the name given to my predecessor that this party is also acquired.
Learned.
Therefore, your
counsel for
lordship
the
directed me
respondents
to approach
seeks
respondent
to
number
use an
6.
affidavit in opposition in this matter. Paragraph, upon consideration of the submission made on behalf of the parties, comma, this court is also inclined to hold that the matter needs to be heard on affidavits. Paragraph, affidavit in opposition be filed within 2 weeks.
Anytime.
Opposition. 3 weeks. Within 3 weeks from date. Affidavit in reply, comma, if any, comma, be filed within a week
2 weeks.
Within 2 weeks
The
thereafter.
whole matter, therefore.
Paragraph, let the matter go out of list for the time being, liberty to mention.
Grateful. Grateful.
Next.
My lord, in item number 15, my lord, I am for the petitioner. Petitioner number 1, 2, and 3 are the rightful owners of the land by virtue of
It's appearing for the respondents. You're appearing.
my lord, the title deed, as well as my lord, they are in rightful position by virtue of the LR records. Everything is annexed herewith. Now, my lord, this is a second round of litigation after hearing prima facie. Your lordship was satisfied and directed the state respondents, my lord, to file a report, to which, my lord, we have filed an exception. Now, my lord, the report which they has filed is, my lord, totally bossed up to mislead this court. Why, my lord, I will show from the report, because there is no demarcation of land. Prima facie, I will establish my case, my lord. Suppose I have, my lord, 100 kata of land. Of this, suppose, my lord, 2 kata of land is acquired. 98 kata of land is not acquired by them. Now, what they are doing, my lord, they are suddenly coming up with a notice and they are saying that we have acquired your land and you have taken a compensation. To that also we have objected to. That is a different matter. I am not dealing with that. But now they are claiming that the entire property is acquired and they are giving a map without any demarcation. My lord, may I go through the, chronology of dates? Date required, chronology of dates. Shall I go? Date. My lord, on 18, my lord, page 1, annexure P1 at page 16 reveals the deed by virtue of which I am the rightful owner. And on 18/1/2021, my lord, the respondents, that is the concerned authorities, mark the private land of the petitioner for extension of Chakda Bonga Road, to which on 24th.
You're referring to the report.
No, my lord, I am referring to the list of dates. On 24/06/2021, my lord, page annexure P3 at page 28 of the writ petition.
Yes.
The respondent authorities came to encroach the land of the petitioner, and on 1/07/2021, that is
P3 to the writ petition.
yes, my lord, at page
It
20.
is sketch map.
Yes. Annexure.
Page 28.
Yes, my lord, it is the sketch map. Now, this sketch map will reveal, my lord, the portion which is acquired and the portion which is not acquired. There is the line, acquired line. The lower portion is acquired and the portion above it is not acquired. Now, they are claiming that the entire land is acquired. Now, to that effect, my lord, a writ petition was filed. Why the order is, my lord, at page 33.
Yes.
My lord, may I go through the order? It is submitted on behalf of the petitioners that a portion of the land owned by the petitioners was utilized for construction of Chakda-Bonga highway by the state respondents without any acquisition proceeding. As a consequence, no compensation was granted to the petitioners. The petitioners intend to submit a representation before the concerned authority in this regard and pray for direction upon the state authorities to consider the same at the earliest. Learned Counsel for the state respondents deny the contentions of the petitioners. Having considered the submissions made on behalf of the parties and material on record, this court is of the view that the petitioners may submit a representation ventilating their grievances before the concerned authority, which may be disposed of by the authority. Accordingly, the petitioner are at liberty to submit a representation to that effect before the third respondent within a week from date. Such representation shall be considered and disposed of by the third respondent within a period of 3 months from the date of such representation, after giving reasonable opportunity of hearing to all the interested parties, including the petitioners. Now, my lord, that has not taken up. What they have done, they have again annexed the same map which they have annexed right now in their report, and they are telling that we have encroached the entire property. It is true that they have acquired a part of the land, and it is also true, admitted fact, that I have taken compensation for the land. But my lord, the rest part is not acquired by them. Now, acquisition has two steps.
Was there any demarcation?
They are not giving the demarcation. That is the thing. They are always giving the report without any demarcation, even during the hearing, even after the hearing. A surveyor was appointed. Government approved surveyor was appointed in their presence. My lord, may I? That is present in my exception. My lord, this is the original map. This hand over for them.
Yeah, there is a map in the exception.
Yes, my lord, but that does not have this red markings probably. That red marking, through the red marking, everything is clear, my lord. The lower portion that has been acquired, but the portion above is not acquired.
This was done by the respondents.
No, my lord. This was done by a surveyor. I mean, government approved surveyor, to which they also in their presence. Yes, very much. And there was contradiction between two surveyors. They are always submitting the same report. Let them demarcate at least the land which was acquired. That will solve everything. But they are always coming up with a report with the entire portion that is encroached. Yes, my land is encroaching the highway. Definitely, if they have not acquired, acquisition has two processes, requisition and acquisition. And notice cannot be valid for, I mean, lifetime. Section 25 is very clear.
Let us hear the state. Page 18, yes.
After demarcation, all are present. After a thorough demarcation, it is found that construction of the construction of the executed with the record of the started to mention here that was the record of land of plot number was acquired by the demarcation has been done, the values of the future they were written and challenging that the entire
The petitioner is claiming on plot number 366. Not 300. On 300, your highway is being constructed. Please see the last line of page 18 that you referred to just now. What is 366? Only 0.017 is acquired. What about the remaining part? No, no, they are not claiming 300 at all. See the writ petition, please. They are claiming 2 decimals in plot number 366. That is their claim. And you say that part of 366 has been acquired. So where is the demarcation of 366? The demarcation held by at the instance of the petitioners show that a part is acquired. The last line of page 18 of your report.
Record of land of plot number 360 was acquired by delegation.
You have put all your concentration on 300, which is not the subject matter at all.
Encroachment on plot number 300.
So not in 366. The plot in dispute is 366, not 300. And in the sketch map prepared by you, I do not find 366 at all. Page 19 of your report.
Here, this is not the road is constructed to block. And here encroachment of 300 and that's on the basis of the adjustment on plot number 300.
Where is it stated that it's plot number 300 in your notes? Notice is page 35. A very vague notice which only says right of way, no plot number mentioned.
My lord, may I hand over the list of dates with the page numbers? It might help your lordship.
Please come to page 36. Again, you say that on 300, the construction is going on. The state highway. Last line of that paragraph, an area measuring 0.017 acres was acquired. So the remaining portion belongs to the petitioner. P36 is an order dated 21st March. Yes, the report of that paragraph, the last line of the paragraph. The remaining part is the petitioner's part. Have you demarcated 300? The petitioner has no claim at all. 300 is not their land. 300.
No, we have no claim to pertain to 300. They are claiming entire 300, 366 is their property. They are not claiming on record.
It's only 366.
We have not stated in our melody.
So I'll
then they should demarcate it, or they may at the best they may acquire the entire land. If it is encroaching their highway, they may acquire it as per the valuation along with solution.
366 is encroaching.
But they are not saying, but while submitting the report, while they are demarcating the land.
300.
But that is not
demarcation of 366.
that is not stated over there. While they are serving me notice, they are sending their main and agent and telling me that to vacate the property. But that is 366. Then my right has to be secured. Yes, demarcate and do not disturb my position.
There should be a demarcation, isn't it? Do you agree to this demarcation made by the petitioner? Only of 300, not of 366. 300, the petitioner has no claim at all. The writ petition says 366. From where do you get 300? A part of 366 has been acquired. Remaining part is the petitioner's part. So you have to demarcate the acquired portion. which has been done by the petitioner. If you agree to this, then no further demarcation is
Yes,
needed.
my lord, I bow down before your lordship. In every writ petition, they are coming and they are misleading this court with 300. Every time we are stating it is 366, a portion is acquired, the other portion is not acquired. Even now, if they want to acquire, they acquire it through due process of law.
What is the entire area of 366?
It is entire area.
You are claiming 2 decimals.
I am claiming 2 decimal only. There are 2 maps. One is at P3, annexure P3, page 28 of the writ petition. Another is with the exception, which has been filed.
decimal মানে কত জানো 1 decimal মানে কি 1 decimal মানে কত এক কাঠ ঠিক আছে
366 is 10 acres.
Yes.
decimal মানে 6টা
The entire done.
ভালো বড় 100 কাঠায় 1 ডিগ্রি
The records say it is 10 acres.
1600 decimal আমরা বাড়ি থেকে শুনতে যাবো না এখন গরমকাল ওই দিন দিয়ে স্টার্ট হবে
The sketch map, my lord, which I handed over, it has categorically mention of the parts which are my part, which are not acquired, A, B, and C.
So unless there is a demarcation of this, there is a demarcation, but there is no demarcation of your 2 decimals.
The sketch map
Because
which
you have not purchased the entire land.
No,
So where is the demarcation of the 2 decimals of land?
the
which
sketch
belongs
map,
to
my
you?
lord, which I have provided before your lordship.
Where does it show 2 decimals?
My lord, the 80 square feet lower portion is acquired land.
Yes.
There is 3 parts, A, B, C. The lower portion, 80 square
There
feet,
are
is
80
acquired.
each. Yes.
Yes, 80 on each part is acquired by them.
Yes.
The other portion behind, that is not acquired, but they are
The entire other portion doesn't belong to you.
the
You have claimed only 2 decimals of the entire land.
yes.
So is your portion demarcated?
No, this is not only for us. There are other petitioners. They are trying to encroach everyone's land, stating that a part is acquired, therefore the entire land is acquired. But they have to demarcate. It is here in this instant writ petition, there are only 3 writ petitioners. But there are other persons whose lands they are acquiring forcefully without due process of law. They have acquired a portion. They may demarcate and say that this portion is acquired.
The acquired area has already been demarcated by your person.
Yes. That is demarcated, my lord.
Why is further demarcation required?
Now, I have demarcated, they should concede to it, or they should give a report. They have already, every time they are giving a report.
Copy of this to Mr. Bhattacharya?
Yes, I do not have a copy. I can share this.
Take this. This is the original. I
This is
believe.
the original.
Take this back, please. Didi, eta ferot diye din. Please take instructions on this and come back.
Even if they want to acquire, they may acquire. We will concede to that. That is the last best thing which may concede to. But acquisition should be with due process of law.
Your sketch map is only on 300. I am asking for 360. 300 is not the subject matter at all. 366 is the subject matter. You have acquired a portion of 366. You are trying to.
Yes.
You are stating you have acquired 366, a portion.
That has been acquisition some LAK's manner, but the road has been constructed on plot number 300.
Then you should not encroach 366.
Yes, so why are you encroaching? You're disturbing the petitioner in 366.
Demarcate and do not disturb.
That is not on 300. That is
It
on
may be in the. Sorry, my lord.
If the petitioners are on 366 and you require that part, you have to acquire it. You cannot just evict the petitioners from there without due process of law. Please take instructions and come.
Bow down, my lord. It is my fundamental right. may be required by you. You may acquire it.
Please serve a copy of the sketch.
My
map.
lord, sure, my lord. এটা আমি একটা এটা তোমার original,
Heard learned counsels for the parties.
না না গভর্নমেন্ট অ্যাপ্রুভড আমি আপনাদের লোক ছিল
This
হ্যাঁ
completed on
আপনি
behalf
তো
of the petitioners
নাম্বার
that
আপনাদের গভর্নমেন্ট থেকে গেছিল তার সামনে ইয়ে হয়েছে ডিমার্কেশন হয়েছে আমি একটা জেরক্স
the petitioners have acquired title and possession in respect of 2 decimals of land in LR plot number 366. And have no claim in respect of LR plot number 300. Paragraph per contra, comma, learned counsel
Well, that
for
is
the
another disputed matter about LR 300. I am not going into that because the acquisition proceeding in the perspective of 300 is also without following due
you
process
have
of
any
law.
claim over 300.
Yes, but now, right now, through this writ petition, I am not claiming anything.
Have no claim to it. Per contra, comma, learned counsel for the respondents submits that the highway is being constructed on LR plot number 300, a portion of which is encroached upon by the petitioners. Stop. Paragraph, the petitioners deny and dispute the said contention of the respondents. Paragraph, it is not in dispute that an area measuring 0.017 acres in plot number 366 was acquired vide LA case number 30/PWD/2003-2004. Stop. The petitioners claim title in respect of 2 decimals of land in the unacquired portion of the plot. Stop. A copy of sketch map submitted by the petitioners submitted na kore annexed to the affidavit of exception submitted by the petitioners demonstrates that only a portion of plot number 366 has been acquired, comma, which is also admitted by the respondents. Stop. Since the state highway is being constructed in plot number 300, according to the respondents, comma, there is no reason why the possession of the petitioners in respect of their 2 decimals of land in plot number 366 should be disturbed by the respondents. Paragraph, learned counsel for the respondents seeks to take instructions in this regard. Very clear.
I said take instruction whether any road has been constructed by plot number 360.
Whether the petitioners have encroached upon any, your concern is 300, not 366. The petitioner's concern is 366. They claim to be occupying 2 decimals in 366. You are constructing your way, the highway in 300. You have, your allegation is that the petitioners are encroaching portion of 300. And they have no claim on this. So please take specific instructions. Paragraph, let the matter appear under the same heading on 14th May.
My lord, only one indulgence, my lord. In the meantime, my position should not be disturbed, my lord. Let my lord, let it be recorded. Otherwise, they are coming every day with new order and they run shop of tea. Poor people.
It prima facie appears that the petitioners are in occupation of a portion of plot number 366, over which the respondents have no claim, comma. The respondents are restrained from disturbing the position of the petitioners in respect of the said portion of the plot till 15th June 2024.
I'm grateful, my lord.
15th June, huh? Next.
No.
But I am for the added respondent.
Please switch on the microphone. You have a very low voice.
Yes.
Yes.
Now, my lord, the affidavit is ready. May I hand up to your lordship? Lord, I am led by Mr. Mitra. I have been given him as a senior from the day one. He was busy in any other court. I said this might be last day. Last.
Playing the truant, as I used to do in school and college.
Lord, I have served. We have served there everywhere. We are for
Lord,
different ones.
Lord, we have been served yesterday. Lord, your lordship kindly grant us some leave to use an exception to this report, so that we can deal with. Yes.
I can't stand in the way. I can't stand in the way. But
Since it was served only yesterday.
yes, it was served late. Well, I can't be very unreasonable with Mr. Ghosh. Well, the only thing is this, I must tell your lordship very candidly. Well, this particular affidavit, which we have filed, well, there are various documents which have referred to here. Well, I had the impression that the copies would be annexed. For example, Gazette notification, then notification under section 5, then notification under section 7. The documents have not been annexed, unfortunately. My lord, may we do this? I do not want to again unnecessarily, since my learned friend is taking time, we shall prepare the bunch of documents which have been referred to here. And my lord, we shall prepare, I shall give a set of documents to my learned friend and we shall file a copy for your lordship. If your lordship permits me, then my lord, we can rely upon that.
You take this back and file a comprehensive affidavit in that case.
I was suggesting this, my lord, this affidavit can be dealt with by my learned friend, just to, my lord, save time. And my lord, by tomorrow or day after tomorrow, I shall give a set of documents on which have been referred to, nothing more, which have been referred to in different paragraphs, not beyond the affidavits. We shall stick to it. And so then, my lord, copies have been given, and I shall hand up to your lordship a set of documents, my lord, at the time of hearing.
A copy also, that also may be served upon me also.
Yes.
Oh yes, of course. I cannot ignore him, my lord. He is much stronger than me. I just can't ignore him.
Yes.
Supplementary affidavit submitted on behalf of the Metro Railways is taken on record. Counsel for the Metro Railways, on prayer of the Metro Railways, liberty is granted to submit the documents referred to in the affidavit on the adjourned date. Paragraph, learned counsel for the petitioners seeks to use an exception to the affidavit. Paragraph, let the matter appear under the same heading on
Your
17th May.
Your lordship will not be here, I am told.
By Guri Sir.
Next week. So I was.
Will you come on 17th May?
17th of May. That will be perilously close to the vacation. Then, my lord, I do not know whether Mr. Ghosh will be able to, my lord, do the work. 9th May. 9th. Good. And, my lord,
9th May.
By what time they will file their.
Fairly at the top, because this matter was directed to be fairly at the top.
Yes, my lord. Kindly do it.
Is it at the top?
It's appearing as fairly at the top. It has been substantially heard.
Yes, my lord.
Tumra copy have, by what time they will file their affidavit to the report, to this affidavit? Tumra কথা ছিল?
Serve an advance copy.
Yes. Yes.
কবের মধ্যে করবে? তোমরা কবে?
না, 9th May.
9th May. 3-4 দিন আগে।
3-4 দিন।
7 May. Yes. 7.
My lord, I am for the petitioner, my lord. 1718. My lord, the last
The field inquiry has been held.
my lord, state, my lord. Sir, sir, the copy লাগবে sir. Sir, the copy
Received
লাগবে.
a copy?
No, no. Petitioner, দুটোতে. Slipped in.
Yes.
My lord, I kindly see, my lord, I have handed over, my lord, the report, my lord, not in the depot status report, my lord. My lord, kindly see demarcation was made on 20th March 2024 in presence of it. My lord, kindly see this, there is no, rather they have encroached the land. My lord, they are the unauthorized occupier. My lord, that's why, my lord, in the writ petition, they have annexed the documents regarding for removal of unauthorized encroachment. My lord, that is at page in the writ petition. Writ petition the page, my lord, 26.
The inquiry was held in presence of the petitioner?
Yes.
Yes.
My lord, I think, my lord, the so far fact finding, my lord, writ court is, my lord, has already delivered a judgment. Writ court is not the fact finding court. My lord, if they are aggrieved at all, they can file a suit at best.
What is the prayer of the petitioners?
Petitioner, kindly see the my lord, kindly come to writ petition page 26. Kindly see. This is the order they have challenged. Removal of unauthorized. 26, my lord. Page 26. My lord, there is a provision for appeal also. In the act itself.
My lord,
Dara,
paying adequate compensation amount to the petitioner against the illegal demolition of the shop room of the petitioner lying and situated in, my lord, since, my lord, the property land was utilized without, my lord, paying any compensation. That was, my lord, my prayer.
Kindly
The petition says that your plot has not been disturbed at all.
My lord, I have to come back, my lord, with an affidavit, my lord.
Again.
This, my lord. My lord,
Since you have served this today, he needs to go through this and meet this. Let him come back.
but I'll come back, my lord. Only,
My
my
lord,
lord.
I only
Well,
make
since-
a humble submission. My lord, so far the statement of the states are statements of states are concerned. My lord, even the unauthorized occupier whose land was taken over, they have got compensation. So many land encroachers were there at that point of time. Petitioner was one of them. Everybody has accepted. He has filed this instant purported petition saying that the portions he has to he is entitled to get the compensation because unauthorizedly, because my lord, kindly consider, my lord, he cannot go both ways. He has made a regarding allegation against the issuance of the notice which is at page 26. My lord, kindly come. He cannot have both ways. Kindly come. So accepting that there is a provision for appeal in the act itself. He did not have, my lord, kindly consider my submission, humble submission.
Lordship is taking up the matter for hearing. I'll also have to refer to, my lord, page 27. There's a decree of the civil court, my lord. I have to show all this, my lord.
Decree of civil court, my lord, kindly consider one thing, my lord, that I took a point before the Honorable Division Bench, the Honorable Justice Dipankar has it then was. My lord, saying that the so far land of the states are concerned, even a decree is be passed, that decree is to be declared as a nullity.
Have you challenged the decree?
No, my lord, that is pending. My lord, I referred the matter to ledger. It is pending. So, my lord, the stand of the affirmed by the Honorable Division.
Is that judgment on record? the Honorable Division Bench's judgment?
Right now, my lord, I can, my lord, right now.
Please come back on the next date.
Oh, yes, I will produce that it was referred to the larger bench.
Status report submitted on behalf of the state respondents is taken on record. Paragraph. Learned counsel for the petitioners seeks to peruse the report. A paragraph, let the matter appear under the same heading on 17th May.
17. My lord, in the meantime, a liberty, my lord, to file an exception if I, my lord, feel necessary. at all.
6 peruse na koro ota ei korun on prayer of the কেটে দিন ওটা on prayer of the reportটা submit হলো সেটা বলুন তারপর on prayer of the petitioners liberty is granted to use an exception to the report comma if required.
Grateful.
Paragraph, let the matter appear under the same heading on 17th May. Next.
My lord, for 18, my lord, I'm yet to get the status report. So,
My lord, ওই একই same. My lord, 17, 18, দুটোই।
Na,
Have you heard together?
my lord, in the top, my lord, it's only, my lord, the case status of the 17 is given, my lord. But
There is also, my lord,
There is a case map which not contains both the plot.
Let that be clarified, my lord, in the order, my lord.
yes, 17.
It is together, so it's okay.
17, 18.
Item number 19, my lord.
আমি আছি।
Appearing on behalf of the petitioner, Miss Advocate Shonchita Bormon Roy is completely on behalf of ECL, who is appearing on behalf of ECL. She is hospitalized, my lord. She has requested to my senior on last night personally.
This name doesn't appear in the cause title. Oh, Shonchita Bormon Roy.
I'm there.
That's
I'm there. In the matter, she was my advocate on record.
She is.
She is my advocate on record.
You're asking for an adjournment on her ground?
No, I'm not.
She has requested to my senior to not to proceed, my lord. That is why, and she's.
I don't know.
Here before us.
And I've not been instructed like that.
Whatever it may be, the entire scenario goes like this. Suppose you are.
Petitioner,
I'm appearing before.
She is for the petitioner. There were the two occasions given. আমি করবো না আপনার বিরুদ্ধে মামলা. There were the two occasions given where she was supposed to file the exception.
Yes.
And this is the third day. I mean, if she is not ready, she can take a
I'm
further
not
time.
a recorded advocate also, my lord. And
You're appearing for the petitioner, you said just now.
Yes, my lord. But
So
my
where is the exception to be filed by the petitioner?
my lord, I'm not
You
been
ready
instructed.
করেছেন?
No, my lord, I'm
না,
not
তাহলে
been
আপনি এক
instructed
সপ্তাহ
also.
সময় নিন, madam.
I'm praying for 2 weeks accommodation
It's
also.
not your playground, madam. This you
Kindly,
should
ma'am.
realize, isn't it?
Kindly, my lord.
You say that you're for the petitioner, you're supposed to file an exception. You've taken several extensions for this. You cannot just stand before the court and say you do not have instructions. Why are you standing here then?
My lord, exception has been filed just.
Where is the exception? Please show me. Please give it to me.
Yeah.
Please give me.
I'm not carrying the file and brief.
Say it has been filed and you're not carrying.
And
What
that
are
has
you
not
saying,
been.
madam?
I bow down before. Gotcha. I bow down.
Please be a little more serious when you come before a court of law.
Gotcha. Gotcha.
This is the High Court. Learned counsel for the petitioner seeks further extension of time to use the exception as sought. Paragraph, as a last chance, the prayer is allowed. Paragraph, let the matter appear under the same heading on 20th May. Petitioner is not in a hurry at all.
Grateful.
Next.
May I please your lordship? I am for the petitioner.
Have you served the private respondent?
On last occasion, Milord has directed us to reserve again the copy of the petition. I have served it and
Anyone appearing for the private respondents?
no.
Yes, what is the matter about?
My case is very simple, Milord. I have a shop room, and before the shop room, there is a land that is demarcated as a road and the private respondent encroached the land and make a pakka structure over that land.
It's PWD road.
It is PWD road, Milord. And they blocked my egress and ingress. I go before the authority. I made several representations, but they did not listen to me and they did not bother to accept my representation. So I come before your lordship to kindly come.
Page 17 is your representation.
Page 12 is my representation, annexure P2 before the SDO, PWD.
Assistant engineer.
Is it PWD land?
My lord, he has stated, my lord. My lord, he has stated, my lord, only two paragraphs read petition. My lord, you kindly come to paragraph number 5, my lord, the read petition. Paragraph number 5. My lord, 2 or 3 paragraphs are there. The private respondents are disturbing the free egress and ingress portion of the petitioner as well as the local people and tried to make forceful construction. Tried to. Only this is the only environment. Then 6 also same a PWD. The petitioner states that the private respondents are still doing illegal act by making construction. They tried here he has stated making construction over the PWD land. So if it is so PWD land, my lord, my executive engineer should be major part.
Assistant engineer.
Assistant engineer should be addressed. My lord, there is no such representation before the assistant engineer.
4 is assistant engineer.
Assistant engineer, but representation
It's stated as assistance engineer.
engineer.
Please
Assistant
correct the
engineer.
cost title
Will you kindly give me a liberty to make a representation to
before the assistant
the engineer?
And please correct this assistance should be assistant.
Assistant.
Milord.
The necessary corrections. right?
Milord.
Yes, ma'am.
Let him file a comprehensive representation.
Yes, my lord. Obviously. Yes. Yes. Obviously.
Affidavit of service. তার আগে
Hmm?
করুন, on prayer of the petitioner, liberty is granted to correct the nomenclature of the 4th respondent in the cause title of the writ petition. The cause title be amended accordingly. It's
Milord,
stated as
I am
assistance.
led by Mr. Bhattacharya.
Affidavit of service. None appears for the private respondents despite service. Submit a comprehensive representation before the authority.
My lord.
Paragraph, the petitioner.
Well, I also
Yes.
find, my lord, the representation comprehensive representation.
The petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have the private respondents are trying to raise are trying to raise unauthorized construction by encroaching upon the PWD road adjoining his property, thereby obstructing his egress and ingress. Stop. The petitioner seeks to submit a comprehensive representation in this regard before the concerned authority and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondents submits that the 4th respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the 4th respondent within 7 days. Within 7 days from date. Stop. The 4th respondent is directed to consider and dispose of the representation within 3 months from the date of communication from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of. Next.
Madam, for the petitioner, that kindly sees the last order. This is my second writ petition.
Who is appearing for the respondents?
That on the last occasion appeared, my lord, your lordship appointed. Kindly sees the last order.
Where is your affidavit of service?
My lord, I have corrected in the writ petition. It has not been served.
On the last date, there was a direction to implead the special land acquisition officer and serve.
I did not serve.
Did not serve. So please come back after service. Mr. Dey is appearing in this matter.
কপি দেওয়া হয়েছিল ওনাকে? আচ্ছা দিয়ে দিচ্ছি আজকে।
Supposed to in the report.
নামটা
Mr. Dey, you wanted to submit a report in this matter.
Well, copy that.
You have not served copy.
I did not, my lord. I am appointed recently, my lord. 2 days back, I have completed that.
So on the earlier occasion, you were not there.
No, I was not there.
On 4th March, you were not there.
I was not.
So have you seen this order?
Yes, ma'am.
You should have complied with it by now. Please do that. Yes.
My lord,
And please serve a copy to Mr. Dey today itself. Here and now.
but
On prayer of the
interim order was
yes.
interim order was there, ma'am. Interim order was there. Last order.
You do not do anything and you are asking for a
I'm extremely sorry, my lord. I will do that today only.
Since service upon the 7th respondent is not complete, comma, let the matter since Nagore, it is just Kurun, service upon the 7th respondent is not complete. Stop. A report in the form of affidavit is yet to be filed by the state respondents. Paragraph, let the matter appear under the same heading on 17th May. Paragraph, the interim order granted earlier is extended till 15th June or until further orders, comma, whichever is earlier. Summer vacation in between.
Wait,
Please comply with this order immediately. Next.
If it's understood. What I beg to you, my lord. Land, my lord, was a requisition under Act 2. By the time, my lord,
Respondents.
Is there? My lord, a requisition under Act 2, my lord. By the time, my lord, requisition, my lord, was not complete, acquisition was not completed, no award has been passed, possession was taken, representation was made. In reply, my lord, they say, my lord, kindly come to page 29. In response to my representation, they say, my lord, 29.
Only state respondents.
State. No award of Act 2 LA case number such and such was declared till date. My lord, they admits, my lord.
Yes.
So as per 2013 Act, my lord, the compensation to be calculated and to be paid.
Act 2 is applicable, 2013 Act.
No, under Act 2 requisition was there.
Was it shifted to Act 1?
No.
By a notice?
No. 993 and 93B not there.
So is Act 2 covered by 2013 Act?
No, either they have to refund our land or to pay compensation in accordance with the prevailing act. There is no other
You
act.
have to make a fresh acquisition proceeding in that case.
Yes. Or rather, my lord, there are orders have been passed. My lord even passed the order to pay the compensation as per the new act. This is my humble. Let me take instruction because there were payment of compensation or the lapse case or not that have to take instruction.
Prime facie, it appears it is done. Let him come back with instructions.
My lord, a
Please
report.
come back with a report.
My lord, kindly pass that order. Retail copy, retail paper. Retail copy. Number.
Learned counsel for the petitioner submits that though his land was requisitioned under section 3(1) of Act Roman 2 of 1948, award was not declared within the stipulated time frame, and the act lapsed and the acquisition lapsed upon expiry of the act. Equivalent was declared during the lifetime of the act. Act as a result of which the acquisition lapsed.
It has been utilized, my lord.
Learned counsel,
It has been utilized.
the land has been utilized in the meantime. Paragraph, learned counsel the petitioner seeks compensation in terms of the 2013 Act. Paragraph, learned counsel for the respondents seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 17th May.
My lord, pass an order, my lord, to file a report in the form of affidavit. To file a report in the form of affidavit.
I've recorded that.
কত লাগে?
Please serve an advance copy.
Date 13th May. My lord, can it be on 13th May?
17th, you have difficulty.
Some difficulty.
30th.
13th. 13th.
Amlan, 13th May.
Grateful to my. Grateful.
Next.
Lord, I'm in this matter, my lord, appearing on behalf of the state, my lord, I'm led by Mr. Ansar.
That's the affidavit of service, your lordship. This is the second round of litigation, your lordship. This is the order in the last state petition, your lordship. This is the second round of litigation. This is the order in the last state petition. The question, your lordship, there are two questions basically, which is before your lordship. The one is that the land has been acquired under the National Highway Act 1956. My land has been acquired. It's a structural building. I have put the evidence on affidavit. It was demolished, the portion which I have been paid for. After getting that payment, the National Highway came with a notice under illegal occupant. So the question which I want to put to myself is, if I have been paid the compensation, I cannot be illegal occupant. Both cannot go simultaneously, because the section which has been implemented defines that on a sudden move, they're finding some illegal occupants just straight over there. My structure was there, they paid the compensation, the photograph and everything is there with the government and the NHA as well.
Who is appearing for the national highways? So they are the answering respondents, I think.
They are also, state is also there. There's two parts. First part.
Of the national highways?
Yes, your lordship.
Ms. Roy is, today I do not find her.
Union of India and state has been served by hand, your lordship, and email has been gone to the National Highway Authority.
Serve and come back. It's only a mail. They may not have received it at all.
That I'll do that.
I will inform Ms. Roy also.
I
can regularize it. Please serve, I'll regularize her appointment. Let national highways be served. Because they also need to respond to your,
there are two aspects. The first aspect, they need to respond. And your lordship only submit for 1 minute. The second aspect is that this is a case where arbitration notice was served upon me. Whatever the maybe, the arbitrator has implemented 2013 Act. They said their benefit should be enlarged. So hence now they have to implement the 2013 Act. The state has never given any sort of hearing or whatever it may be that this 2013 Act has been implemented. They have accepted because the arbitrator order has been challenged by the state government. So that has got absolute, the order is absolute. Now the state, because there's a transit phase. The National Highway Act initial calculation of the National Act 1956. Now when the arbitrator said it has to be done under 2013 Act.
That is enhanced.
Yes. So they have to now again reopen, and because the 2013 Act says every individual should be served with the independent order. Yes. So nothing has been there on record.
Mr. Mondal, please take instructions in this regard. National Highways Authority of India is not complete. Comma, let the matter stand over till 17th May.
17 May.
Please take instructions in the meantime.
And I will serve and come with
17 May.
Next.
Online 24, my lord, I have to kindly ask for a week's adjournment, my lord, because
You're not ready?
no, my lord, we have actually not found a brief, my lord. That is why we are.
On the earlier occasion also you took an adjournment. So please be ready on the next occasion.
Yes, my lord.
Yes?
Yes, my lord.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17th May.
17th May.
Next.
Madam, for the state respondent in this matter.
I have served everybody. I have checked up. So I have made a representation before the assistant engineer alleging the ingress and egress of the petitioners has been blocked
by unauthorized construction that has been carried out by the private
Have
respondent.
you served the private respondents?
Yes, my lord. Yes, I have checked up, my lord.
They have all received?
Item delivery.
Yes.
The representation
Sir.
appears at page
This is
35.
PWD land.
Yes. The representation appears at page 35, annexure P3.
Page 35.
Yes, madam.
39 ও তো আছে তোমার 39
Assistant engineer.
39 also has made the representation to the assistant engineer. Lord, I have got the police report, though I haven't received the assistant engineer report. From the police report, it reveals, Lord, there is a title suit is pending with the petitioner and private respondent. Lord, your lordship kindly.
That should be in respect of
in
private
respect of
property.
Private
Private-
property.
Title suit cannot be pending before in respect of PWD land.
For that 107 proceedings, this is a police report,
That's why I'll give you a suggestion.
my lord.
Mr. Rao. Please do not ask the police to give reports in writ petitions. They do not know the difference between a title suit and a writ petition.
Then, my lord, one thing, your lordship, can either I will come back with the report, or your lordship can direct the assistant engineer,
Here and
assistant engineer to following up on all the private respondent and all, and decide the matter.
Well,
Yes, my lord. That appears at page 39.
so let that be considered. That's a later one.
That's correct.
Yes.
Yes, ma'am.
Assistant engineer, PWD Hooghly Shodor.
Affidavit of service. None appears for the private respondents despite service. Paragraph, the petitioners claim to be the recorded owners of the plot in question and submit that the private respondents have raised unauthorized construction by encroaching upon PWD land, adjoining their property, thereby obstructing their egress and ingress. The petitioners submitted representations before the concerned authority on 8th February 2021 and 12th April 2022, which are yet to be considered. Representations go, na? The petitioners in this regard, the petitioners pray for a direction upon the authority to consider the representations at the earliest. Paragraph, learned counsel for the state respondents submits that you've not implemented the assistant. Yes, 5.
Yes, ma'am.
The 5th respondent be directed to consider the representations in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the 5th respondent to consider and dispose of the representations submitted. I am asking for both. Representations submitted by the petitioners dated duto date given respectively, such and such respectively, within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents,
Ah.
in accordance. Disposed of, Richard. Next.
His Lordship, I am appearing for the petition. By order dated 6th March, your Lordship directed the state respondent to come with instruction. The land was taken for construction of road, no compensation, and the direct purchase scheme was also not affected.
Kindly have a look, my lord. For expansion, there was a proposal from our end, and it went up to Highway Division has requested initially. Then, my lord, it went up to the cabinet, and cabinet approval has not been granted. So no fresh land acquisition proceedings would take place. only improvement, whatever the land is there, whatever the road is there, only that would be improved.
All this part is over by a decision in the earlier writ petition, I think. Direction. for
Respondent number 5 is still, we are waiting for he to come back on this issue. All these petition.
Your report really doesn't mean anything. These are all over, these parts.
Kindly,
The order in the earlier writ petition.
On 25th July 23, your lordship specifically directed to do it. That was not implemented. The construction work was hurriedly going on. It was completed. The claim of the petitioner is ousted. Now they are saying that the decision is pending before the cabinet.
No, now it has come back by
For
negative.
For acquisition, not for direct purchase. Direct purchase proposal has already been initiated. There was a direction for concluding the same within a stipulated time frame. That has not been done.
Let us come back with that instruction next week. Respondent number 5 টাকে ধরো ওর নাম্বার বার করো কি অর্ডার পাস করছি
অর্ডার পাস করছো
Instruction which is
direct
necessary.
purchase.
If the earlier order has been complied with, that's all. That's the only instruction to be taken.
এই নাম্বারটা ফোন করো
Similar order already passed. How what
Have you
instruction?
filed a contempt application?
No.
Why?
No contempt application. This order has been passed. Similar matter order has been passed. Not my case.
তোমার এখানে কি ফ্যাক্ট আমি জানি না
Fact similar fact. Fact is similar.
Writ petition is primarily for compliance of the order of the earlier writ petition.
Lordship.
Nothing more.
Yes. Lordship.
That's why I'm suggesting a contempt application would have been more effective.
Lordship. Lordship knows very well content.
You are kind to the state. Let the state come back.
Very short date this week.
Next week.
Next week? Same matter. On prayer of the state respondents, the matter is adjourned. Statement of facts submitted by the state respondents is taken on record. On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17th April.
17th.
Kindly add positively. That would help because I tried my level best. I could not get the information.
Personally confessed me.
I have just adjourned it because it's only this is on the earlier occasion the order was passed. Come back, let's see.
Next matter is same.
17th April next week.
Same heading বলুন।
পরেরটাই হ্যাঁ আপনি আছেন অর্ডার শিটে তো আপনারা দেখছি আগের দিনে
The next matter also.
নেক্সট সেম 17 এপ্রিল থাকছে ইনস্ট্রাকশন নিতে বলছে হোয়াটস নেক্সট
My lord, what is the order, my lord? I am for the
অ্যারেস্ট করা আছে দেখুন
no. My lord, কি order দিল?
In an earlier writ petition, there was an order for completing the proposal for direct purchase. It was initiated. This writ petition is for compliance of the earlier writ petition's order. So you wanted to take instructions as to whether it has been complied with. Order dated March 6, 2024.
এটার বেসিসে স্টেপটা কি হয়েছে সেটা
I'm fixing it on 17th next week. It's similar to the earlier matter. Rajiv, same order. Rajiv, এটাতে written instruction নেই। Prayer of the correspondence. Matter is adjourned.
Sir, both the matter happen in same heating, madam. Otherwise, my lord, the difficulty.
Yes, same heading, same date.
Yes, madam.
Rajiv, under the same heading. তাই তো বললাম।
May I please, your lords? My lord, yesterday when I was moving.
727 and appearing for the state.
My lord, what happened? The petitioner is the owner of land, my lord, about more than 2 bighas. In 1982, my lord, a proposal was offered for requisition. Subsequently, land has been acquired. That is they are saying. But till date, no compensation has been paid. When earlier writ petition was filed, kindly look at page 19.
19. My lord, I have typed it out. This is the writ petition is not being opposed, although Mrs. Manjari Gupta, learned advocate, is appearing with the Mrs. Ila Chatterjee, learned advocate for the state respondents. And this writ petition was taken up for hearing by me on July 6, 1990, when at the instance of the state, 3 weeks time was granted to file the opposition on behalf of the state. And the matter was adjourned for 1 month from date. Thereafter, the court to appeared before the August Satanshas, the state respondent appeared through Mrs. Manjari Gupta, learned advocate, Ila Chatterjee, learned advocate, but no affidavit was filed. Mr. Samar Banerjee, learned advocate, at the resumed hearing on August 21, has submitted since the land has been requisitioned for settlement of immigrants in terms of the provisions of the West Bengal Land Development and Planning Act 1948, since the land purpose being the limited nature, the land cannot be indefinitely kept under the purview of the requisition under the provisions of the said act. Mr. Banerjee further submits, has drawn attention to the court to the recent next typing palette, to the recent observations of P.N. Bhagavati CJ in the case of T.N. Bhora versus Satanshaj, recorded in Satanshaj, as the well observations of Sobhasati Mukherjee, J in case of Jawan Devi Purkait versus his land acquisition such and such, to the effect that the land cannot remain within the purview of the requisition for an indefinite period, and if the respondents needed the land for the public purpose, which is of perennial nature, the respondents will be obliged to take recourse to the acquisition of the land by payment of compensation, which has not been done in the facts and circumstances of the present case. Further, according to the said two judgments, the respondent authority directed to the requisition the land from the purview of temporary act if requirement has already been fulfilled. Mr. Banerjee has drawn attention to the court to the statement made in paragraph 8 of this writ petition, wherein the writ petitioner has specifically alleged that the respondent did not take any action since 1965 regarding acquisition of the land, as because it was provided in the Standing Act 55, so that no scheme shall be necessary for acquisition of land for public purpose, namely settlement of immigrants who have migrated to province West Bengal on account of circumstances beyond their control. Thus, according to the writ petitioner, the LDP scheme shall answer. My lord, then skip over after next page. No affidavit, so in opposition has been filed on behalf of the state is controverting or dealing with the said allegations in the writ petition. This court is of the opinion the respondent should be directed to pass necessary order for release of the land from LD case number such and such, and the respondents are also directed to take steps for acquisition of the land if the land is still needed for any such public purpose in terms of the adjustment in case of such and such. Such consideration and release and acquisition should be made within 3 months from date of communication of this order. Nothing was done. Then another writ petition. That is, my lord, in 95. Justice N.K. Mitra was, my lord, pleased to pass an order. Page 23. The land acquisition case is still pending, and the compensation have not been paid to the to be disposed of, and be paid within 5 months from the date of communication of this order. It is disposed of. Nothing has been done. Then, my lord, in the meantime, the original, my lord, litigant died. Now, his only legal heir, she made an application. Kindly look at, my lord, page 25, translated, typewritten page 25A. Most respectfully, begs to state that I am the only legal heir of Haran Krishna Chatterjee of such and such. My late father Haran Krishna Chatterjee was the owner of such and such plot. After the death of my father, on November 1996, I became the owner of the said land, being the only legal heir of late Haran Krishna Chatterjee. The said land was acquired by the land acquisition collector, North 24 Gunas, in LD case number such and such, challenging the said acquisition. My lord, they has given the case history, and ultimately it has been prayed, page 26A. Although the order dated 2696 was handed over to the then land acquisition collector, he did nothing
to grant or receipt to that effect. During his lifetime, my father did not receive any compensation of the said land, and after his death in November 11, and I have not received any compensation of the said land till date. Therefore, you are requested to take steps in the matter so that I can get compensation in LD case number such and such. Well, this is the fit and substance of the matter. It is a valuable land in Dakshineswar area. Then, my lord, I, through lawyer, requested, page 27, the special land acquisition collector and, my lord, the additional land acquisition officer, non-compliance of the order by such and such, my lord, of the two orders reference. This is to bring to your kind notice that my client, Anima Chatterjee, daughter of late Haran Krishna Chatterjee, such and such, long ago you sought to acquire the subject land of the father of my client, and subsequently you have acquired the same.
You Asked for compliance of the order.
Yes, yes. So, my lord, this is 2 bighas and 14 chotak land in Dakshineswar.
Let us hear the state.
I have to take instruction on this matter, my lord, because allegations have been made that non-payment.
Petitions,
I know, my lord.
then two.
Allegations are there, but I have to verify from the records what has been done by the authorities. My lord. I have not received
Non-compliance.
non-compliance. So I'll have to ascertain that. Lord, kindly allow me to come back with a report. Lord, I'll apply the lordship. What has been done?
ঠিক আছে, no problem. কিন্তু অনেকদিন আগে দিয়েছি কপি।
Report আসেনি এখন, sir. Report আসেনি।
My lord, kindly, that's why yesterday I said she is, my lord, aged about 90 years.
Affidavit of service. Paragraph, it is contended on behalf of the petitioner that despite earlier orders passed by this court.
এটা তুমি ফোন করেছিল না?
For release or acquisition of the land in question belonging to the petitioner within a stipulated time frame and representations submitted before the authority pursuant to the said orders, no step has been taken by the authority. Paragraph, learned counsel authority till date. Paragraph, learned counsel for the respondents seeks to. Will you come back with a report?
With a report.
Submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 10th May.
10th May. My lord, I am greatly pleased.
Well, at least during her lifetime, and she will get something on CD.
No, there's a gap of 12 years also. They are not hiring so much, but for 12 years they were silent.
Court orders.
I'll have to ascertain that.
This is this.
And the second order asking you to comply, then representation, demand of justice, nothing has been done.
These are the allegations. I'll ascertain and come back.
These are the documents, not allegations.
No, non-compliance is the allegation. The directions are on record.
Instructions, yes.
10th May. I'm grateful.
Next. Yes.
Well, I am for the petitioner, my lord. This matter appeared at the instance of the private respondent, my lord. My learned friend has mentioned this matter, my lord. Last occasion, your lordship was pleased to, my lord, direct, my lord, the state respondent, my lord, to submit a report. In the meantime, my lord, we have challenged, my lord, the authority of, my lord, the Bali executive officer, Bali municipality, my lord, to issue notice. Now, my lord, this notice was issued pursuant to a direction given by an honorable division bench in connection with a public interest litigation matter, my lord. Your lordship was initial observation was that be added as a party in the public interest litigation, my lord. We have, my lord, applied for, my lord, the addition of party, my lord, that is 18th is date fixed. So, my lord, let us report be submitted today, my lord, the matter may be fixed, my lord, after 18th, so then, my lord.
But appearing that matter, this matter doesn't need to be proceeded with.
No, that was prima facie your lordship's observation, because at that point of time, my lord, we are not made parties, my lord.
It's the same issue actually. Which
No,
is
not is the same issue, my lord. This was done, my lord. This notice, my lord, which was under challenge, my lord, was done pursuant to a direction given by the honorable division bench. Now, my lord, we have, in this petition, we have, my lord, challenged, my lord, the authority of the Bali municipality for issuance of notice so far the demarcation party is concerned. Now, lordship direct, that's why lordship directed, my lord, state respondent, my lord, to submit a report including the demarcation report.
Let me just adjourn the matter today. If I still find that this court can deal with the matter, I'll.
Or, my lord, lordship can do subject, or your lordship can do, my lord, subject lordship can consideration, my lord. Let the matter go out of the list, my lord, subject to the, my lord, decision of the outcome of the appeal matter. Let the matter, that order can be passed.
Let it, if Let the matter be in the list, my lord, because we can
Let it be
satisfy
adjourned
regarding the
by some
jurisdiction
time.
part.
Let me adjourn it by consent of both the parties.
Yes, my lord.
Since a prayer for addition of parties is pending before the Honorable Division Bench.
But I am on
By-
behalf of the private respondent number
by
12 against
consent of
whom
the
the
parties.
allegation was made for filling up the court.
By consent of the parties, the matter is adjourned. Paragraph, let the matter appear under the same heading on 22nd May. Should be sufficient.
My lord.
22nd May.
List.
It is only done. Next.
729. I am appearing.
Have you served the respondents?
I am not affidavit of service. Father of the petitioners was the owner of a particular plot of land that is
National Highways.
now arbitrator.
There
Let
is
me
affidavit of service.
yes. Let me will
The National Highway should be is a party, isn't it?
is a party, but
Affidavit of
effective
service.
party is my learned senior science client.
Affidavit of service to the happening.
State government has been served.
What about the National Highways?
If requires, well, I can, but
Like, can you have implemented the National Highways project director? This is Mr. Day is not representing.
because of the fact that the district magistrate, let me place my one minute.
You will place after service, not before that.
My lord, according to
Mention
case-
My lord,
according to
kindly
case
cease.
35, my lord, he is bound to service all the parties.
Yes,
Right.
since the NHI is implemented as a party.
Then, my lord, 1 week time, I am serving upon
May.
May.
Since service upon the NHAI is not complete, comma, let the matter stand over affidavit of service never should have. Affidavit of service never should have. Since service upon the NHAI is not complete, comma, let the matter stand over till 16th May. Next.
Can it be preponed, my lord?
Come.
In the under the same
I
heading,
have
it will appear.
circuit bench for 2 weeks, so
I
that's
see.
the difficulty.
Under the same heading, it will appear.
Mention that.
But 7:30, my lord, I am for the petition. Lord, I start, Lord.
I beg to appear for the state. My lord, I am appearing for the private respondent. They have wrongly implicated two persons, but same person. And my lord, an order was, frankly speaking, my lord, an order was passed by my lord, Mr. Justice Bhattacharya for removal. We have complied the same, but at the same time, we have preferred an appeal. Appeal is pending.
You
And
have
my
not
lord,
complied. Your lordship kindly see.
kindly
page-
see,
Page, your lordship kindly see. Page 37. Page 37.
my lord, this
At
picture would,
page-
my lord, make the picture
Let
clear.
the petitioner complete
Yes.
his
Yes,
submission.
your lordship kindly see page 37 at page 41. I'm disturbing 1 minute. So I is appearing for the NHA. May I have the copy upon her? She is willing to.
Can she receive?
Yes, it
You have
can.
to serve the authority first.
She is
Authority has
willing-
not been served. Can you receive a direct copy? No. The authority, I can direct only upon service to the authority. That has not been done at all.
I shall serve upon the
Serve
authority
the authority. If they do not
as well
appear, I'll
as to
request
her.
Mr.
As well as to her, both copies. Now, dear lordship, kindly see first page 23 of this honorable court. Order passed by this honor. Page 23.
This is page 37 is the earlier order of the court.
Yes. That is order is 12th February to 2021. Thereafter, again order was passed. I will, so because Lord, proceeding has been started, then they prefer an appeal. Against that, they came before this court.
Where is the order impugned?
Yes, your lordship kindly see the
September 8 order.
lordship kindly see page 37. Page 37.
37 is the writ petition.
Judge Sahib's order.
Blood.
It refers to an order impugned dated September 8, 2023
Yes.
of the authority. Where is that order?
Yes.
Where is that order?
But again, that is not your lordship kindly see page. They will not prepare an appeal. Your Lordship can see page 28. Page 28.
No, where is the initial order?
Like the initial order is page 25. Section 10 order. Page 25, your Lordship can see at
10-3
page
order.
26.
Yes.
At page 26. Last. At page 26. Then they prefer an appeal. That is what page 28. Page 28, at page your Lordship can see the appeal, page 20 at page 34.
It was dismissed.
Dismiss. Then Lord, against that, they prefer the writ application. That is at page 37. Your Lordship can see at page 44, 41.
Yes, yes.
41.
Yes.
Yes. Then your Lordship can see they against that they prefer an appeal on the month of October 2023. Since then the appeal is pending, no interim order, nothing, and they made a letter. But 42.
দাদা কোন অ্যাপিলের কথা বলছেন? সুপ্রসচিব হচ্ছে যে পরে আবার কিসের অ্যাপিল?
তার against a
তার against appeal করেছে
mandamus appeal.
mandamus appeal. হ্যাঁ।
That mandamus appeal
That
is
appeal,
pending.
they
And my
filed,
lord, what he is saying.
nothing is done.
No, what he is saying, 100 times we mentioned, your lordship knows all the
That
matter.
is the different thing. But
different-
no interim order. But they have not proceeded. Only
But-
on the basis of a letter sent by them, they stop the matter.
No,
But
in the
but they don't respect the order passed by this court.
my lord, kindly, he is making, my lord, all along misleading statements. We have already removed the this is the picture, we have demolished everything.
So why have you preferred the appeal then?
Appeal prefer, my lord, that they have made some wrong misleading statements, misled the authority and order was obtained. But to show the bona fide of the order passed by my lord Bhattacharya, we have.
Request Mr. Dhot to come back with instructions whether the obstruction has been removed. As,
Whether they have removed or not.
as claimed by Learned.
But they have now says they have partly removed.
That photograph
No,
means
not
nothing.
partly.
Neither can or
Nothing was done.
Nothing.
So for my instruction.
This, nothing was done.
Nothing,
You
nothing.
are not the government.
I am not the government, but I am the party.
They are, my lord, they have encroached lot for.
That is the different thing. No,
They have encroached, my lord, on the government land.
That is the
Now the
different thing.
encroacher, my lord, is shouting.
The encourager is out.
The dacoits are saying that you are a thief.
I need to take the instruction.
only to the effect whether this has been demolished or not.
Yes.
এই তো,
The council
my lord,
says they have removed.
they have undertaken before the single bench.
Yes, that is the
Now they
consequence.
cannot turn back and say.
That's why we have
They say they have already removed.
Removed.
Now he is saying partly removed.
not partly.
There,
I mean,
there
why
was no undertaking in respect of partly removal or whole
no,
removal.
I did not give an undertaking. The honorable court was pleased to grant some
I
time.
will take the instruction whether it's fully removed
Yes.
or not.
It has been, my lord, fully removed. The picture would make the scene clear.
So no further instruction is necessary. I'll record that if it is fully removed, fine. If it is not, it will be removed within 2 weeks from
Yes.
date,
Yes.
from today.
Yeah, Lordship.
No, but my lord, but one thing, my lord, the appeal is,
But,
but when appeal is, we have prepared the appeal.
but you have said you have removed. That's why
No,
I'm
no,
not-
remove, my lord, just to show respect to the orders passed by the honorable court, we have
You
removed.
show full
but-
respect, not half respect, is it?
No, not full. But if we ultimately,
It's partial
if
respect.
we succeed, my lord, we can restart. If we
Yes,
succeed
yes,
in
you
the
can
appeal,
restart. If the division bench says you can restart, remove it now.
There is no
This is the
stay,
point.
so there is no embargo. My lord can pass
Yes.
that
And-
order.
hundreds of
Yes,
appeals are
your
pending
lordship
there
can-
without any stay.
Your Lordship pass the order.
In spite of our best efforts, matter is not being.
When he is submitting before the court, he has fully removed. There is no.
No, you are talking about the
My
cases
lord can
pending.
record his statement and my lord.
Hundreds
the
of-
order.
In one appeal, my lord, at least 100 times I have mentioned it has not been listed. What can I
My
do?
senior friend has just now submitted, his client has fully removed.
This is the picture. This is the picture it has been given.
Kindly record that.
Only on that submission and passed out. nothing else.
This is the picture they have
Yes.
given.
On the basis of his services,
From
your
the
lordship pass the
public
order.
road,
Your
my
lordship
lord,
pass the order.
from the public road, I have fully removed.
Heard,
Kindly from the public
evidence.
road.
Paragraph heard learned counsels for the. Yes, you are not supposed to remove from your own land.
Yes, kindly record that public road. From the public road.
Your land is not the subject matter
Yes.
at all. Only
No,
the
no, they are saying.
subject matter.
Yes. Kindly record that from the
The subject
public
matter.
public road. Kindly, my lord. My lord, some lawyers shouts in such a way that I cannot shout.
Because you have a fairly loud voice, sir. You don't really need to shout.
He's shouting more than me.
That is his normal voice. He has a fairly loud voice.
God, eh.
People with soft voices need to shout.
Yeah.
You have a nice,
cannot shout.
loud voice.
I
You don't need to shout at all.
No, I know his voice. He is in a my lord. No, he is very polite, and I also, my lord, normally in a soft. তুই আমাকে মারবে ভাব করছিস। Anyhow, we have removed from the public. That is it. আমাকে যা ছবি দিয়েছে রে ভাই।
Heard learned counsels for the parties. But the paragraph, the private respondents were served with a notice under section 10(1) of the West Bengal Highways Act 1964, alleging unauthorized construction by encroachment upon PWD land. Stop. The proceeding was taken to its logical conclusion by an order passed under section 10(3) of the Act on 21st October 2022, against which the
রাস্তা থেকে
private
আমার
respondent
তো অসুবিধা নাই সেজন্য তো বলছি
referred
সেজন্য আমি
an
বললাম
appeal under section 10(4) of the Act. Stop. By an order passed on
ওনারা বলছেন একটাও কিছু হয়
এতে গেল কি
Page 28.
13th December 2022, comma, the district magistrate and collector, comma, Murshidabad dismissed the appeal
দিয়েছে সমস্যা দিয়েছে
upon affirming the order under section 10(3) of the Act. The order of the district magistrate and collector was carried in appeal by the private respondent before this court. No, it will get it. The private respondent approached this court against the said order in a writ petition being WPA 28862 of 2022. Stop. By an order passed on 30th August 2023, comma, a coordinate bench of this court directed the private respondent to remove the encroachment and make over vacant possession in favor of the state authorities within September 8, 2023. Stop. The learned court.
I'm sorry to but kindly come to paragraph 21 of that said order. Para 20. This direction was made
Yes,
on
yes.
the basis of
Yes. The learned court directed the respondent authorities to implement the eviction order impugned by due process of law in the event the private respondent did not comply with the order. Stop. The order was passed on an undertaking given by the private respondent before the court
Undertaking কোথায়?
to remove the encroachment within 7 days from date. Paragraph. Learned counsel for the private respondent submits that though the private respondent has carried this order in appeal before the Honorable Division Bench of this court, the order has been complied with by removal of the encroachment
From the public land. This is the picture.
from PWD land as undertaken before the learned single bench. Paragraph. In view of the above,
And
this
one
court is inclined to hold that since, according to the private respondent, the entire unauthorized, the entire encroachment made on PWD land has been removed by the private respondent, the state respondents are directed to
বহু সময় কি থাকে জানেন তো, পিডব্লিউডি রোডের পাশেও সার্ভিসের জন্য কিছুটা থাকে। এখন সেটা তো আমি বলতে পারবো
verify
না কোনখানে সেটা।
the said statement made on behalf of the private respondent stop in the event the encroachment is not removed by the private respondent, the state respondents are directed to remove the same within 2 weeks from date.
Grateful to.
And one thing, my lord, they have also
Now,
made some
in terms of
encroachments.
the
In,
order
my lord,
passed by this court
at the same time, my lord,
on 30th August 2023 in WPA 28862 of 2022. Paragraph, since nothing further remains to be adjudicated in the petition, the same is disposed of.
yes.
There shall
My lord, one thing, they have also made some encroachments on the
Instead of 2 weeks, my lord, I am seeking 4 weeks because of the election.
Oh,
I don't know, my lord, when
already. You have to only go and find it.
if we are to, my lord, if we are to go there and demarcate whether fully removed, if something remains, then we need to remove as per this
In
order.
4 weeks. 2 weeks to 4 weeks.
And another thing, my lord, those,
ওরা গেছে একটা রিট ফাইল করছে নাকি?
তাই করো।
কিছু হবে, ভেঙে দিই নোটটা, আপনাকে ধরে চোটটাও ভেঙে দিই। তুমি বলো।
and my lord, they are also the encroachers on my, they should also be removed.
Lord, I advise him to file a writ petition.
তাহলে তো পয়সা হবে কাজ।
Next.
I am grateful, man.
Lordship, I beg to appear on behalf of the private respondents. Lordship,
I beg to appear.
Lordship, before going into the merits of the matter, Lordship, kindly see.
State.
Lordship, I have a humble prayer before your Lordship. Lordship,
He's appearing for the state. You are appearing.
Lordship, before
Okay.
going into the merit of the matter, Lordship, kindly see whether this matter is at all maintainable under Group 1 or not. Lordship,
Fine.
they have made a representation before the State Highway Authority. Matter has been filed under State Highways Act. Lordship, admittedly, this land where petitioner resides is under Group 4, is under Panchayat area. The disputed land, which is alleging that we have made a encroachment, that is also falling under Panchayat area. They have made a representation before the State Highways Authority. And moreover, Lordship, I will show your Lordship that there is an approach road.
Encroachment is on PWD road.
There is an allegation, mere allegation. I will show from the records that there is an approach road towards the national highway, and if there is, the statute provides that if there is a approaching road toward this national highway or state highway, no need to uh, no need to there is no need to keeping extra space. They have sufficient space for their ingress and egress.
Are you occupying PWD land or you?
No, Lordship. This 622, he has, under the averment, he has not properly written, but kindly come to paragraph number 5, his allegation.
Do you say that do you claim?
Let them file the representation before the appropriate authority, then come.
This is PWD road, isn't it?
He is not withdrawing for the objection regarding mental weight. I hope. The
No,
objection regarding
no,
mental weight.
I'm not.
comes
I'm
under
not
land,
with.
because if it is a land enforcement of land, it is coming under group 1. So that
And it is PWD land.
that is the allegation. So I'm not worried.
And Lordship kindly sees the
Because,
Panchayat
the
administrative rules. It says that
same ইতে করা আছে petitioner কে বলতে তো হবে because আগে বলবে
let
petitioner submit.
Panchayat rules are not relevant here because the petitioner says this is PWD land which has been encroached upon.
But
They have
record
filed-
says the
1 minute, sir. They have filed an application before the assistant engineer, right? If the
Yes.
assistant engineer feels that he doesn't have jurisdiction, doesn't have the authority, he'll return it. Simple.
My-
Let it be sent to him without further wasting further time.
And my lord,
Standing
one
on
thing
horns.
is, may I permit it, my lord? My lord, in page number 52, my lord, I have annexed, my lord, in the same DAG number, my lord, the proceedings under section 10 of the West Bengal Highway in the another encroachers, my lord, was, my lord, going on. And my lord, the competent authority also passed this, my lord, the order. So, my lord, this DAG number, whether that is, my lord, under the PWD or not, my lord, that is the best authority, my lord, for, my lord, the state authority, my lord, to decide this.
Lordship kindly come to paragraph now.
Why are you so impatient, sir? Let him complete. I understand
don't-
your impatience.
I don't
because you're
realize that he has
you're
not
the
complied.
illegal occupiers, I can understand, but then let him complete.
My lord, in
The order that you're pointing out, page 52.
my lord, 52,
The
para-
encroachment is under 622
my lord,
in plot number 622.
my
But
lord,
in your
my
writ
lord,
petition,
and my lord, petition, my
it is
representation,
577, 578, 579.
In representation, they have mentioned 622. I think.
622,
Page
my lord.
23.
Page 23, my lord,
23, Lordship will find the allegation of 620.
622,
Page 23.
22nd
23.
paragraph, but I find mention of 620.
622.
Oh, these are his own dugs,
My lord, it is
his own plots.
my
622, yes, the
my
same
lord,
plot. So it has been decided by the authority that it is PWD land
my lord, that is
at page 52.
Yes.
my lord.
So that solves the issue.
No. Page
The authority
53, it has
decided
been
it was-
written as a report has been at the last paragraph of page 52. The assistant engineer Kagdip Highway Division, subdivision, submitted a document by such and such. This is quite illegible. On behalf of the executive engineer, Diamond Harbour Highway Division, wherefrom it appears the DAG number 622 is mentioned as Noyanjuli, which is not excess land, such and such. But Lordship record says that land records that
It says that
I have-
may be required for further future extension of road.
yes,
That is what
Lordship,
has been
that
said.
that is a different aspect, but Lordship kindly sees this. The land Rayot is Jela Porishad, Dokhin 24 Pargona. Right hand side top. Land is falling under Noyanjuli, and record says Jila Porishad is the Rayat.
So if it is,
So he has not made any representation before the Jila Porishad.
so if it is Jela Porishad Noyanjuli, it has to be under the 62 Act, I think, not the 64 Act.
Land.
No,
Public land.
This public
So
land.
it is diluting some issues.
This has to be before, this is technical. File an application before the Jila Parishad.
My lord, kindly disposal this,
And-
my lord, this matter.
Yes.
Because, my lord, kindly directing to dispose my representation. Because, my lord, whether it
Direct
is the
whom
Jila,
to dispose. Have you?
my lord, the assist page,
And what another
my
thing,
lord,
Lordship,
executive engineer, my lord. Executive engineer, my lord, it is the respondent number 2. কোথায়?
Hey,
Lordship, another thing.
কাউকে-
Lordship, another point.
একটু কাউকে পাঠান তো কাগজটা উড়ে গেল।
And
There's
my
a
lord,
finding that the fruitland is maintained by PWD road since prolonged time and the fruitland is required for proper maintenance of road and free water flow. I don't know, let the point be decided. Let them take this point that
Because-
this is not, my lord.
and my lord,
I record that because in the earlier order under 10(4), it is already held that it is under the
Held.
PWD.
PWD.
So, my lord,
So let
Even
it be sent to the PWD. If they still feel it's not,
Mild.
they'll send it to the appropriate
And
authority.
even my lord in page
Lordship,
number
another thing,
53,
Lordship.
53,
Lordship,
my
if your Lordship kindly comes to West Bengal Panchayat rules, Gram Panchayat administration rules. Rule 21, sub-rule 3 says, wherever there is a service road or approach passage available, no direct access from a building shall be permitted to a public road. And public road explanation has been given for the purposes of this rule. Public road means a national highway referred to the National Highway Act.
The Panchayat Act,
Yes, Panchayat Administration Act.
not
Lordship, they have,
my lord, my lord, the
petitioner has
assistant-
diluted so many things.
assistant
That's
engineer,
all your submission.
assistant engineer, my lord, already admitted in page number 53 that the plot number
I've seen that.
622, my lord, is adjacent to the road which is maintained by the Diamond Harbour Highway Division.
Yes,
PW.
I've
And
seen
Lordship,
this. I've seen
Pradhan
this.
has filed a report that sufficient space is there to the approaching road to the
Yes,
national
sir.
highway.
Can you still encroach upon PWD land?
But he is saying
Pradhan
in
has
paragraph,
no role to
Lordship,
play here.
kindly come to paragraph
The
number 5.
Pradhan
What
has
is
no
his
role to play here?
allegation in the writ petition? Paragraph number 5.
My lord, let the same the
Last two
decide to
lines.
the competent
Last two
authority.
lines. Lordship, may I try mine? As a result, for the aforesaid illegal possession, occupation and encroachment, which is actually caused total obstruction of ingress and egress to the highway. This was his allegation that due to that illegal encroachment, he could not ingress or egress. And due to that, he is praying for demolition of that encroachment.
Sir, are you aware why this egress point is taken into these writ petitions? So that this doesn't turn into a public interest litigation. If the petitioner doesn't say that his right is being jeopardized, it becomes a public interest litigation. And that is secondary. Primary issue is whether there is encroachment on PWD land. So let that be decided
There are
by the
so many
authority.
encroaches. Maybe we are not alone. There are so many encroaches.
Have you filed a writ petition to that effect?
No, no, no.
So let the authority
We are on the
decide.
same
You will be
same
given
footing.
an opportunity of hearing before the authority.
Yes, Lordship. Yes, Lordship. That too. Affording
Yes, yes,
opportunity to us also.
Absolutely.
Obliged.
The petitioners claim to be the registered owners of the plots in question, and complain that the private respondents have encroached upon PWD land adjoining their plots, thereby obstructing their egress and ingress. So the petitioners submitted a representation in this regard before the concerned authority on
Represented on my
page 19.
11th December.
2023, which is yet to be considered.
Hmm.
Stop the petitioners, pray for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the private respondents submits that the plot in question has been recorded in the LR record of rights as plot belonging to the Jela Purishad, South 24 Parganas. Learned counsel for the state respondents submits that the third respondent
My lord,
be directed to consider the representation in accordance with law. Paragraph. It transpires from an earlier order passed by the district magistrate, South 24 Parganas,
my lord,
on 3rd August 2021 in an application under section 10(4) of the West Bengal Highways Act, 1964, filed by other encroachers of the plot in question being plot number 622, that the said plot is maintained by PWD within bracket roads
Diamond Harbour
and
Highway
is
Division.
required for proper maintenance of the road, free water flow and development/extension of the
road
highway.
My lord,
Therefore, it can be prima facie held. Therefore, it can be prima facie held that the plot in question is under control and supervision of the PWD. Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law.
Private respondents hearing. 9 to 23 are yes.
Dispose of.
Obliged, Lord.
I have some matters from your lordship, 7:34 till 7.
Yes, it will.
Yes, tomorrow I have some personal difficulty, your lordship. It's a bunch of
Ask someone to appear, I'll consider.
My lord, under compelling circumstances, I am mentioning one matter, my lord.
Not the mentioning time, I'm sorry.
Well, group 7 matter is wrongly, my lord, it is appearing in the heading, my lord, group 1 matter. The matter was fixed today under the heading group C.
Number 10.
Item number 48, my lord.
48 group 7 হবে।
Yes,
Yes, call the list.
There are two matters, my lord, analogous.
The Sen is appearing in this matter. Mr. Shamanto for the petitioner.
778. 778.
Mr. D.K. Shamanto, you are appearing.
I missed the matter.
It's only one thing.
Yes.
778.
No, I think both of us missed.
No, no, আমার নয় গোপা বিশ্বাস
এই না না অর্ডার শিটে নাম আছে বলছেন মাই লর্ড দেখে নাও
না
Mr. Shamanto is appearing. BP Shamanto and D.K. Shamanto.
শম্পা মন্ডল
Yes.
মানে কস্ট আইটেম মানে হ্যাঁ না শম্পা মন্ডল গোপা বিশ্বাস অ্যাডভোকেট
দেখে নাও
let me check up my let me check up my
make it not today bala later
Only not today.
my lord
not today not this week
they will teach you not this
bala make it not this then পরে দেখবা
Didi, একটা order for. I'll just pass an order. Let me get the
For that reason, I have. This is Prasanto Sadhuna.
Oh,
I am here.
appear করেছি
Yes.
Mr. Sen is appearing.
Yes
But it's the wrong cost title it has appeared.
now I realize yes প্রশান্ত
So
সাথে
no one is appearing for the petitioner today.
I am for the petitioner.
You are for the petitioner.
This matter which was brought to your lordship.
WP number is the same, but possibly the name of the petitioner it appears
printed.
Oh.
Wrongly printed. Prasanto Sadhura. Wrongly printed because wrong print.
but simple manner making not to done not that is
Not to the
Not to the man.
not this is simply not to the কালকে correct cost title আসে
কালকে পরশু ছুটি আছে
হ্যাঁ পাইছি তো
কপি কোথায় গেল
ম্যাটারটা 23
কপি বাড়ি আছে
কিন্তু ওই বার করবে 778 দাগ দিয়ে দেন
The number is also wrong. এটা কি হবে আসলে 23 হবে তাহলে এটা করে দিন একটু ইন্টারপ্রেট করে দিন করে দিন
শান্ত সাধু হবে
তাহলে অ্যাডভোকেট নাম হচ্ছে
22 থেকে 23 হবে।
সব
ভুল হয়ে গেছে ভুল হয়ে গেছে
আপনার হ্যান্ডি
Let it appear on 19th.
90
Let the matter appear under the same hearing on 19th April by consent of the parties. By consent of the parties, the matter is adjourned. Consent adjourned. ওইটার পরে correction পরে by consent of the parties, the matter is adjourned. Let the matter appear under the same hearing on 19th April.
হ্যাঁ মানে ওরাই পাঠিয়ে দেয় অ্যাপ থেকে পাঠিয়ে দেয়
Same.
But in this matter, my lord, but a supplementary report has been filed by learned friend, but I have to use an exception that is not yet prepared, my lord. Let
To
it,
use an exception to this.
my lord. That has not yet been prepared, my lord. Your lordship kindly adjourn this matter for.
Learned counsel for the petitioner seeks to use an exception to the supplementary report.
Submit. I have already submitted. Mr. Devra has already supplied
Submitted on behalf
supplementary
of
report. That would be supplementary report. Supplementary.
Paragraph, let the matter appear under the same heading on 13th May. Please serve an advance copy. Next.
I appear for the petition, my lord.
My lord, I think, my lord, there are several matters.
Exception clause.
My lord,
Exception clause.
Madam, madam, এটা দিন, এটা দিন।
My lord, এটা কবেকার অর্ডারটা দিলে বলো?
আগের অর্ডারটা।
আগের ডেটটা বলো।
3/4/24 এই অর্ডার 3/4/24
WP
হ্যাঁ হ্যাঁ
333.
হ্যাঁ
Well, I think, my lord,
হয়ে যাক দিচ্ছি।
when this matter was taken up, 533 of 2024, my lord, on instruction, my lord, I made this submission that let there be an interim order for a limited period, and in the meantime, we shall file our affidavit.
You want to come back on affidavits?
Mine.
Because there was a different interpretation of the clause on the earlier date, so far as I can recall.
Well, the matter is there.
And Mr. Roy,
At the initial stage, I submitted that without affidavit can't be decided. Now, my learned friend has realized
it's required.
but it is required. To some extent, it is required. Although it depends upon the one line of the notification.
Mr. Roy is asking for some time, some breathing time for his clients.
No, I am ready today. If my learned friend wants to argue, I am ready.
Well, since my instant to file affidavit, so my lord,
Very.
because whatever, my lord, I can, my lord, whatever I can.
Here
tell
is
to-
already an interim order. So you
Already
can't
interim
extend
order.
Yes,
So
let the
that
interim
matter
order,
also.
let the interim order be continued.
30th June.
Yes. Or until further order. Or until further order, whichever is earlier.
On instruction, on instruction. We are talking.
Learned counsel for the state respondents submits, comma, on instructions, comma, that the matter needs to be heard on affidavits. Paragraph, affidavit in opposition be filed within 4 weeks.
Within 4 weeks.
4 weeks from date. Paragraph, affidavit in reply, comma, if any, comma, be filed within 2 weeks thereafter. Paragraph, let the matter go out of list for the time being. Paragraph, the interim order granted earlier is extended till 30th June or until further orders, comma, whichever is earlier.
My lord, there is no interim order.
Yes,
In
there
all-
is.
But in all the matters, interim order is there.
And it has been extended from time to time.
Yes, yes, Lord. সবগুলো আছে তো।
interim order ছিল।
হ্যাঁ ছিল।
2252.
2252.
Yes, there is an interim order. It has been extended from time to time. I'll call one by one,
Yes,
just to
yes.
find out.
Right.
Next.
ম্যাডাম অর্ডারটা দেবেন?
My lord, interim order, my lord, till
30th June
30th
or until further orders.
or until.
Identical order, Lord. Identical order.
I'll file an affidavit.
Please, interim
Mr.
order. is
Sen
there.
will be leading the argument, Mr. Sen and Mr.
Oh,
Devra.
this is an interim order. Yes, same order. Ashok, same order.
$2
782.
Not identical matter. Similar matter, order may be passed.
Interim order is there.
Yeah, is there.
You should out of list. Same order, Bashu.
For the petitioner, my lord, your lordship was pleased to issue interim order on the earlier day, madam.
Same order.
Same order.
I'm appearing.
783.
73.
এখানে একটা একটা করে দিই না। Same order.
The order of the similar order may be passed in terms of the permit. Your Lordship, in paragraph 2, the alignment of the route has been mentioned, madam.
Same.
On the other day, Mr. Sen could not appear. Your Lordship was pleased to not to pass an interim order.
No interim order till date,
Ah.
but I give it to your Lordship.
Let there be an
Adjusted with the
Same.
Learned counsel for the respondent seeks to use affidavit in opposition in this matter. Paragraph affidavit in opposition be filed within 4 weeks from date. Paragraph affidavit in reply, comma, if any, comma, be filed within 2 weeks thereafter. Paragraph, let the matter go out of list for the time being. Stop, liberty to mention. Paragraph, since the permit granted in favor of the petitioner is valid, comma, let there be an interim order permitting the petitioner to continue to ply his vehicle in terms of the permit granted in his favor till 30th June 2024 or until further orders, comma, whichever is earlier. Next.
Mala, I appear.
No, same.
It's also one of first time, there is no interim order, just like Mala earlier.
Vashu,
86
आगे turn. 785.
86.
I appear for the similar matter.
There is an
Same order may be passed.
Vashu, extension of it. Same order, extension.
788 also similar matter. Similar order may be passed.
There is an interim order. Vashu, same order, extension.
Similar order may be passed. Similar matter.
There is an interim order.
Yes.
Vashu, extension, same order.
কেউ আছে বোধহয়।
Well, in this matter, depending on behalf of the petitioner, now this matter was heard on.
Private.
Yes.
Actually, he has taken the NOC. So I'm paying for an upload.
In the last occasion, matter was adjourned, that the sale some cause of action, another it was not filed. So actually, I have checked up, my lord, these are separate cause of action, so I not have.
No, you
Only what, not today,
stated on the
only
earlier
make it
date
not today.
that an identical writ petition was filed earlier, which has been disposed of.
Yes.
Are you ready with the copy of the writ petition?
Yes, I have copy, I have copy.
You have a copy?
Yes.
The NOC is taken. We will do.
Only make it not today.
I'll just make it not today in that case.
Only make it not today. Bibliography.
E-rickshaws, man.
E-rickshaw, on similar order, 100 matter was not same.
Not
Similar.
today. Next.
চলবে না?
So I am for the petition. I have served upon all the respondents, my lord. My lord, this is the matter. My lord, petitioner is a registered leaseholder with the Indian Railways. My lord, before taking part in a tender process, my lord, it is a rule that one has to register themselves under Indian Railways. And for that, they have to submit certain documents. Upon verification of those documents, the railway authority grants registration. Upon granting that registration, it gives the authority, it gives the liberty to to the said person to take part in a tender process. Yes, participation. Now, my lord, under the registration of petitioner took part in several tender processes and emerged as the highest bidder. And at the material point of time in 2019, 5 years back, my lord, petitioner was operating 6 to 7 trains under Eastern Railway. Now, my lord, in one of the trains, which is from Shialda to New Delhi, Duronto Express, my lord, petitioner was conferred with a, for transporting consignment, he was given a parcel space. Now, my lord, petitioner duly took part in the transportation in respect of the said lease agreement was also executed. And there was no complaint. Petitioner was paying the freight charges along with other trains also. On one such incident which occurred at Shialda station, my lord is well aware of the fact, the rules, that before I load any consignments in the particular space, I have to declare it in a form of a manifest before the railway authority. Because what kind of goods I am transporting, what is the description of the goods, how much it is weighing as per my declaration concerned. So I have given that declaration that such and such description of goods will be transported from Shialda to New Delhi. The rules and the laws says that you can only use one manifest. Wherever you want to unload, you describe that part also. If you want to take the entire goods to certain destination, you have to mention that also. Now, my lord, the allegation of the railways is this, that I have used two manifests. Now, one manifest I have submitted before the Shialda station, before the authority, where I have described that in 3.9 tons of parcel space, I will be transporting 3.8 tons. That is within the carrying capacity. And under the rules also, there are provisions that what I say is not sacrosanct. It's subject to verification by the railway authorities themselves. The rules of 27.8 is there. And also there are other rules in the commercial manual. Lordship has seen that railway officials, they will verify it. They will pass the consignment through in-motion weighbridge. And if it is found it is within the permissible carrying capacity, then they will allow that consignment to be transported, or they will simply ask me to offload the excess materials. Now, that didn't happen. It was allowed to be transported to New Delhi. Now, my lord, what has happened actually, I have unloaded certain goods at Kanpur station. And it's also a fact, my lord, that I have to, in such a hurry, I have deposited one manifest before the concerned authority that I want to unload certain consignments. Fact is this, I have not said so before the Shialda station. Now, the two manifests came at the possession of the railways. One where I have submitted before the Shialda station and one which I have submitted before the Kanpur station, but not at Shialda. So two manifests, they have calculated this total weight.
The Kanpur manifest is to the extent of goods offloaded in Kanpur?
Offloaded. Now, as the rule says that I have to submit it before the Shialda station, so that I have not done. Hurriedly I have, it's inadvertent mistake on my part, I ought to have done it. But whatever the description of the goods, it has not crossed beyond the tolerable limit. So it was very much within the tolerable limit. Now, basing on the two manifests, my lord, they said, no, you have done something illegal act. So we will take into account the weight mentioned in both the manifests. And they have imposed me punitive charges at Delhi stations. And I was penalized. That was a single case of overloading on the basis of documents, but not on the basis of consignments. Now, my lord, on the basis of that, my lord, I was issued with a show cause notice.
You have paid the fine?
I have paid the fine. Fine has been realized from my. So, my lord, I was issued with the show cause notice saying that why your registration shall not be cancelled because you have attempted to defraud the railways. Now, my lord, the clauses which have been shown in the show cause notices are all pertaining to misdeclaration in the manifests. Now, my lord, I gave a reply to them that it is not my intention. I have not carried any extra materials because it has to pass through in-motion weighbridges, and you have allowed us, and all the preventive checks were adopted and applied in my case, and no overloading was found in Shialda station before such departure. Now, my lord, they were not satisfied with my reply. they cancelled my registration. So when someone cancels my registration, my lord, in this train, along with other trains which I am operating, against where there is no such allegation, and this is also the only allegation in respect of this particular train, and out of 1,000 days of loading, one such incident has been detected. Now, they cancelled my registration, saying that I have misdeclared. There is a provision of appeal before the department. I have preferred the statutory appeal, not once but twice within 1 month. Actually, they didn't do anything, they kept quiet. In the meantime, they floated tenders in respect of, as because I was not, my lease agreements were terminated, my lord, I was not allowed to operate. They floated fresh tenders in respect of all these 6 to 7 trains. Now, my lord, I challenged those tenders before this honorable court, my lord, as because my appeal was pending before them, so they should not create any third-party right, because that will take away my right altogether. This honorable court, my lord, came to a finding. I have annexed all these documents that the result of the tender shall abide by the fate of the tender shall abide by the result of the writ applications. During the hearing, my lord, they said that yes, your appeal has been decided, and we have rejected your appeal and confirmed the order of cancellation. Now, my lord, that was placed in the so my writ petition becomes infructuous because separate cause of action arises. Then I withdrew the same. Lordship has allowed us to withdraw the writ application. Excellent, madam. And Lordship liberty was granted to file a fresh writ application. Liberty was granted to apply fresh writ. Lordship, fresh writ application was preferred, which was registered as WPA 20106 of 2019. And as it was a single line appellate authority's order without any reason, Lordship was pleased to set aside and grant and relegated the matter before the appellate authority to take a fresh decision upon giving me an opportunity of being heard. Before the appellate authority, my lord, I also placed my written notes of arguments, annexed all the documents there, and that was considered, and it was again rejected, and that rejection order is before your lordship under challenge. Now, my lord, the only yes, I was given an opportunity of hearing. Lordship, I used that opportunity. I placed my written notes of argument. I have categorically dealt my points. Now, my lord, I want to, Lordship, firstly highlight page 103, that is the show cause notice. Lordship, you have the writ application. Yes. Lordship, this is the show cause notice. Lordship, kindly see what they have stated. The total weight of the packages was found to be 49461. That is overweight, and 2 packages excess. You have acknowledged as overweight by way of depositing the undercharges by such and such, and above act is your violation of the agreement clause 14.0. 2 manifests were drawn by you, ex Shialda for NDLS, showing 120 packages weighing 3880 kgs, and for CNB 20 packages weighing 2000 kgs, and NDLS 1880 kgs. It may be noted that the manifest having packages for NDLS was only presented before Shialda outward parcel office for endorsement and record before start of loading. Manifest containing entries of CNB and NDLS was never presented before Shialda parcel office for endorsement and record. It may be noted that agreement clause 12.4, preparation of only one manifest in case of loading from an originating station to different destinations. Agreement clause 12.8 provides for signature and stamps of parcel staff originating stations, and all copies of manifest will retain 1 copy of the record. In the above check, it is revealed that the manifest for unloading at CNB was prepared in addition to the manifest for NDLS, which was duly endorsed, and 1 copy kept as record by Shialda parcel office. Preparation of additional manifest and mischievously endorsing it with stamps and signatures of parcel office is in violation of agreement. Kindly mark these clauses 12.4, 12.8, 12.11. Such act of preparing and declaring and submitting one manifest at originating station and sending another change manifest in the train for unloading at CNB, that is Kanpur, my lord, which was not submitted at Shialda office, shows malafide intention on your part to keep railways in dark about the loading particulars. Now, for sake of natural justice, competent authority has decided to give you opportunity to represent yourself on the above mentioned issue before taking any punitive actions. So, my lord, kindly see the clauses which they have shown, that is 12.4, 12.8, it will appear at page 39 of the writ application. Page 39 of the writ application. She has found 12.1. Leaseholder shall be required to prepare detailed manifest in the prescribed format as given in Annex 3 of FM Circular 6 of 2014 for consignments being transported by him in the leased parcel space. Leaseholder shall also give declaration as given in Annex 4 of the said circular. Now, my lord, thereafter 12.8. All copies of manifest will be signed and stamped by the parcel staff of originating station, who will retain one copy as record and return the other copies to the leaseholder. Thereafter 12.11. So the leaseholder shall be prima facie responsible for correctness of entries made in manifest as well as actual number of consignments physically loaded available in the leased brake vans. So, my lord, these are all pertains to the loading particulars. So their allegation is this: I have not made correct entries. I have made another manifest which I have not submitted before the Shialda. I have some malafide intention to defraud the railways, to keep them in dark. So I have committed an offense and I should be penalized. Now, my lord, my reply was not satisfactory according to them. And at page 106, they have cancelled my registration. This is on 24/6/2019, which will appear at page 106. Would you kindly see this? My lord, they have invoked clause 4.25 of the agreement, read with clause 4.15 of the agreement, and in the last two paragraphs of page 106, they have stated, in accordance with clause 4.25 of the Freight Marketing Policy 6 of 2014, incorporated in clause 28 of relevant agreement, your registration is cancelled with forfeiture of registration fee of 50,000, and all existing contracts of Mrs. Mark Ali Enterprise is to be terminated along with forfeiture of security deposits. So all my contracts have been terminated, security deposits were forfeited. So this is the cancellation of registration part. Now, my lord, the clauses which they have applied, that is 4.25 and 4.14. So my respectful submission will be, these clauses are not at all applicable in my case. So they have wrongly applied these clauses. So you kindly see page 152. Yes. Now you kindly see page 152, clause 4.25. Prior to that, Roshi will come to page 149, under which clause 4.24 and 4.25 is coming, which is at page 149, that is registration of leaseholders. It's coming under the head of registration of leaseholders, page 149. Clause 4.
Yes.
So, my lord, kindly skip to 2-3 pages. Let us, Lordship, come to page 152. Let us read 4.25. If any information, declaration made by the leaseholder is found false at any stage before or after award of the contract or deliberately defraud with the railways, his registration will be cancelled and registration fee will be forfeited. In addition to forfeiture of registration fee, all his existing leasing contracts being operated from the division would also be cancelled. Now, my lord, this clause 4.25, as per my respectful submission, cannot be read isolatedly. It has to be read along with clause 4.24 also, which is preceding the clause 4.25.
it says the applicant while submitting his tender bid, Lordship, is very important. The applicant while submitting his tender bid shall be required to give declaration that his registration has not been cancelled earlier by any zonal railway division on punitive measures, and he or his firm has not been debarred from entering into any new tender. The declaration shall be as under. Lordship, these are the particulars. Lordship, may I read these particulars? Whether the tenderer is already registered leaseholder in any zonal railway divisions, if so, details thereof. Whether their registration has been cancelled by any zonal railway division, if so, details thereof. Whether they have been debarred for fresh registration by any division zonal railway, in details thereof. Whether any punitive action has been taken by any of the zonal railway divisions, if so, the details thereof, and whether the railway dues are pending against them at any zonal railway divisions. So at the time of registration, not at the time of tender. Tender comes belatedly. At the time of registration, I have to furnish these documents. If those documents are invalid or fake, then in that case, the railway has the authority to check and verify. And if they see that these documents are, the information which I am furnishing is not tallying with the documents, they have every right to cancel my registration. So the scenario here is the post-contractual obligations. It is not that I have misdeclared at the time of registration, that I have given some false documents, false informations, or invalid informations. It is not their case. Their case is this: I have misdeclared. I have made some wrong entries. I have made 2 manifests. My respectful submission is this: the clause 4.25 and 4.24 are only applicable if I make any false statement at the time of filling up the forms regarding registrations. It has nothing to do with post-contractual matters. If they found that any declaration which I have submitted before the authority is fraudulent, then they can cancel my registration. And my respectful submission is this: if the offense is misdeclaration, then under this policy of 4.25 and 4.24, they have no authority to cancel my registration, which they have done here. Now, my lord, I do not say on the basis of this policy itself. My submission is based on, my lord, the section 66 and 163 of the Indian Railways Act, which has an overriding effect.
The Railways Act.
Yes, my lord, I'm giving.
Yes, sections.
Section 163. Rashu has what the
Yes.
Rashu, kindly see section 163, what it says. Rashu has found?
Yes, yes.
Giving false account of goods. If any person required to furnish an account of goods under section 66, Lordship, I will take your lordship to section 66 also, gives an account which is materially false, he, and if he is not the owner of the goods, the owner also shall, without prejudice to his liability, to pay any freight or other charge under any provision of this act, be punishable with fine which may extend to 500 rupees for every quintal or part thereof of such goods. So the offense of misdeclaration, as per section 163, Lordship, kindly mark it, only says that I will be fined monetarily, which they have done, and I have paid. Now, my lord, kindly come to section 66. Yes. Section 66, subsection 1 first. My lord.
This is the manifest.
This is the manifest, because only through manifest I describe the goods. But if I make any false declaration, my lord, accept that
that I have made any false declaration. For argument's sake, I accept that I have made a false declaration. I have a malified intention to defraud the renters. I've hidden some information from them. Even then also, Section 163 says that if on detection, you will be fined only. Then kindly come to page 60, section 66, my lord. Power to require statement relating to the description of goods. The owner or a person having charge of any goods which are brought upon a railway for the purpose of carriage by the railway, and the consignee or the endorsee of any consignment shall, on request of any railway servant authorized in this behalf, deliver to such railway servant a statement in writing signed by such owner or person or by such consignee or endorsee, as the case may be, containing such description of goods as would enable the railway servant to determine the rate of such carriage. Now, my lord, kindly come to clause 4. Subsection 4, my lord. Subsection 4, sorry, my lord. If the statement delivered under subsection 1 is materially false with respect to the description of any goods to which it purports to relate, the railway administration may charge in respect of the carriage of such goods such rate not exceeding double the highest rate for any class of goods as may be specified by the central government. So, my lord, the offense of misdeclaration, even if I, for the sake of argument, I accept that I have misdeclared, I have made a false averment, it does not give authority to the railway administration to impose penalty of cancellation of registration along with termination of all 5 trains which I am operating. And also my respectful submission will be that clause 4.25 can be only made applicable at the time of registration if the documents which I furnish is false and invalid. Now, my lord, thereafter, lordship, I have taken your lordship to the provisions. Now, tenders were issued after cancellation. Lordship will come to page 126. I have challenged the tender. Order page 126. Yes. My lord, may I read, my lord? Lordship has found. Mr. Chatterjee, learned senior counsels.
Earlier petition.
Yes, I have challenged because once they have cancelled my registration, my lord, I immediately filed the appeal. Appeal was pending before them. And during pendency of the appeal, in order to at least, my lord, to end my case once forever, they have floated tender so that I lose my right. So challenging those tenders, my lord, I have filed this writ application. And during pendency of this writ application, they submitted before this honorable court that we have cancelled, we have dismissed their appeal, cancelled them. Now, for that arises a fresh cause of action for which I have filed another writ application, challenging that appellate authority's order once. That appellate authority's order, my lord, lordship's order is there, which is at page 130. Yes.
This writ petition is also pending.
This writ petition has been disposed of. Yes. 20106 has been disposed of. And earlier writ petition challenging the tender that has been withdrawn. That has been withdrawn. Upon withdrawing, this writ application was filed, the order which is at page 130. This order, lordship's order is there. The writ petition, may I read the order, my lord? The writ petition assails the order passed by the appellate authority communicated to him on 12 September 2019, primarily on the ground that the petitioner was not given an opportunity of hearing by the authority prior to passing such order. It prima facie appears that the decision taken in the appeal turning down the prayer of the petitioner was communicated to the petitioner by a letter issued on 12th of September 2019 by senior commercial manager for the principal chief commercial manager, and there is nothing on record
to suggest that the petitioner was offered an opportunity of hearing before the authority prior to passing such order. In view of the above, and upon consideration of the submission made on behalf of the parties, this court is inclined to hold that the petitioner ought to be given an opportunity of hearing before the appellate authority before any order is passed therein. Accordingly, the order of the appellate authority communicated to the petitioner by letter dated 12th September 2019 is set aside. The appellate authority, being the third respondent herein, is directed to revisit the issue upon affording reasonable opportunity of hearing to the petitioner and also other stakeholders, if any, and pass a reasoned and speaking order within 1 month from the date of communication of this order in accordance with law. The decision taken by the authority shall be communicated to the petitioner within a week. Therefore, the writ petition is thus disposed of. My lord, on the basis of this direction, my lord, the authority gave me an opportunity of hearing. I took part in the hearing where I have used my written notes of argument, which is appearing at page 132.
130?
Yes.
2.
132, my lord, annexure P11. My submission is very much reflecting here. And I have categorically stated, my lord, may I take your lordship to the first page? Our first, Roman 1. Our first submission is that while issuing the letter of cancellation of registration and leasing of contracts of Mrs. Mahakali Enterprise on 24/6/2019, the senior DCM Shialda had not considered our reply dated 17/6/2019 issued in response to the show cause notice dated 23rd/5/2019, whereby we have categorically denied the allegation leveled against us. It is the allegation of the railways that during preventive check, 2 manifests were found for NDLS showing 120 packaging weighing 3880 kgs and second manifest showing 20 packages weighing 2000 kilos for Kanpur Central and 100 packages weighing 1880 kgs for New Delhi. It is the further allegation of the railways that only the manifest containing materials for New Delhi were presented at Shialda office. Assuming but not admitting that the contents of the allegations are true, then also there is no variation in the weight. In both cases, the total weight remains 3880 kilos. It is not the case of the railways that the petitioner was carrying goods over the permissible carrying capacity, and therefore the question of security and safety of the passenger does not arise in the present case. In the said letter, the railway has sought to terminate the contract relying upon clause 4.25 of FM Circular 6 of 2014. It is humbly submitted that said clause 4.25 has to be read in conjunction with clause 4.24. The clause 4.24 of the said circular provides. My lord, therefore the clauses has been, which I have shown, my lord, that has been reiterated. The next page, clause 4.25 can only be applicable in case of misdeclaration or false declaration made at the time of the leaseholder. It is not the case of the railway that the leaseholder has made any false declaration at the time of his registration as leaseholder, and therefore clause 4.24 is not attracted, and consequently clause 4.25 has no manner of application in the present case. Since clause 4.25 on the basis of which registration was cancelled has no manner application in the present case, clause 4.15 of the policy is consequently inapplicable in the present case. Parameters mentioned in the same clause, repeated failure to start loading after the award of contract, deliberate fraud, the railways, repeated violations of any stipulations are not attracted here, since cancellation has not been made on the basis of cancellation clause. Cancellation clause 4.15 is equally inapplicable in the present case. My lord, I have highlighted them, but they have not considered all these things, and they have affirmed the order of cancellation that is appearing at page 136. And this is the challenge here. They have again applied clause 4.24, 4.25, 4.15. My respectful submission is these have no applicability in the present case, as because there is statutory provisions. Statutory provision section 66 and 163 clearly says, even if I make any misdeclaration, then I have to be punished monetarily, which they have done so. So this is my respectful submission, my lord. But the crux of my submission is this: they have exceeded beyond their jurisdiction. They could have at least cancelled this contract, but what they have done, they have cancelled my registration. They have taken out my livelihood from me. This is at present my respectful submission, my lord. I have a right of reply to what my learned friend says.
Yes. Will you continue on some other day, because I'll take up the other matters also. They're all waiting.
Then in that case, my lord, let there be a stay of the operation of the appellate authorities order.
That I'll object to that.
There's nothing.
Because my friend has, there are two aspects in this matter. One is with regard to, only I'll take 2 minutes for making your lordship understand why we are opposing this scheme. My lord, there are two aspects in this matter. My friend has explained section 163. That is with regard to irregularity. There was an irregularity on the part of the leaseholder, and for that reason they were fined. He was explaining that at best he can impose the fine, and that has been already taken from him. That was imposed because there was difference of the weights in the freight when there was a sudden check at the Delhi station. That was the destination. The raids are conducted by the vigilance department, and it is under the direct surveillance of the railway board, my lord. So when this vigilance was conducted at New Delhi, there was a difference of around 1,000 something weight. So a fine was imposed, and they paid the fine. Lord, that was an admitted fact on part of them. Lord, the second part, that was the irregularity which my learned friend has tried to explain in 163, and that can be to the extent of 3 times. It's that the irregularity can be done to the extent of if the 4th time they come, then their registration will be cancelled.
Yes,
that is there. So this was the first time they were caught, and so there was nothing to that effect. But the second part, which is the frauding, why we are saying in the explanation also fraud, because they are supposed to make one manifesto. There is one manifesto. My lord, they have not annexed the manifestos in the with this petition, my lord. My lord, the first one which is folded, which is folded one is the second, my lord. I am handing this over to your lordship to make your lordship understand what has been.
Are you submitting a report?
I will, but just to make it your lordship understand, my lord, I'll show the page number. Is the first one and the folded is the second. My lord, with regard to this manifest, my lord, there was a misdeclaration which my learned friend is pointing out. With regard to the misdeclaration, there was a misdeclaration with regard to the weight. Now they prepared 2 manifests. The first manifest was deposited at Shialda. That bears the signature of the staffs at the at the Shialda station. Now, when the consignment was unloaded at Kanpur, my lord, a different manifest was given. So it is not the case that the same manifest was given. That doesn't bear the stamp of the railways. Neither it bears the signature of the staff. So totally a new manifest was manufactured, and at that point, if your ballot will come to page 266, that is
petition.
No, if I reported that is of the railways, 266.
I think Mr. Roy is in.
He should have annexed that, but he has not.
No, if
I will go by the provisions, my lord, and the finding of the appellate authorities.
They come to before this.
Fact, I am not a fact finding authority.
There is a suppression of facts. He is suppressing material facts.
No suppressions.
Because he should have annexed this
After appellate authorities order.
Yes, because
after appellate authorities
that
order
is the basis of the order, Miller. This manifest is the basis of the order which has been passed.
Why don't you come back with a report?
Appellate authorities order. No, stay.
Fraud.
No.
Part of the lease
it is
order.
nothing a fraud. Misdeclaration has never been termed as fraud.
Appellate authorities order is at page?
Appellate authorities order is at page 136, my lord.
So kindly come.
Which
After
is challenged in the petition.
yes. Appellate authorities order is at page 136. And after this order is passed, I don't think my lordship will go with the facts. Because 136. Everything is written here.
My lord will kindly come to page 144. That is the order.
And I have challenged their authority.
Ordering portion.
Provisions are there. By just saying fraud, my lord, it will
And 4.25,
not going to help them.
Information declaration made by the holder is found false. 144. That is specifically on that point itself. We have not passed order the cancelling the lease on the part of irregularity. We have cancelled this lease, his registration.
Practicing fraud deliberately. That is your case.
But lordship will find from the cancellation of registration, no such clauses were applied. No.
I don't mind fixing it tomorrow or day after tomorrow also.
The prayer in the
Prayer in the writ petition, my lord, is at.
Kindly come to the second part also. One
fund of the security, the
Yes.
deposit, the penalty and resumption of operation. You've not referred to the tenders at all.
My lord.
Fresh tenders have been floated.
My lord, probably that is running empty.
So in that case, no interim order.
No, running empty means, my lord, if lordship stays the impugned of appellate authority's order, because lordship will not go into the facts. Facts has been brought by them. It has culminated in appellate authority.
Not stayed at this.
My security deposits. Lordship, my security if lordship stays, then I will be operating the parcel spaces.
we are not.
Because why I say so, my lord?
No question of stay at.
Then in that case, my lord, protect my financial part. Financial, but they should not. No, they should not forfeit my security deposit and enjoy it.
It's already forfeited.
Well, there is no such.
But we have not liquidated. It's forfeit.
Oh, that in that case, they should not liquidate, my lord. In that case, they should not liquidate.
From the bar, I don't think it will happen.
My lord, kindly do not think only one thing, my lord, is this.
So I can take this assurance from you that it will not be.
They have seeked an opinion with regard to that also. I have asked them not to liquidate because since the matter is.
Then that be recorded. That may be recorded.
That doesn't require.
Because they have done something wrong as per the provisions. Provision does not allow them to do so.
The court will decide whether they have done something
My lord,
wrong or it's wrong on your.
No, my respectful submission, my lord. No, my lord, respectful submission.
Not required, please come back.
Then in that case, my lord, I leave.
Of service. Counsels for the parties. Paragraph of the matter appear under the same heading for further consideration on 13th May.
My lord, only one respectful submission. As on present date, let my learned friend apprise the court whether someone is operating or not.
I don't know.
But if any third party right is created, my lord, this writ petition will become infructuous. That has to be gone down in right. My lord, no third party right may be created. At least so that if I succeed ultimately, my lord, at least I will be favored.
Sections with regard to because I don't have this officers are not.
Then in that case,
I have just made your submission that there is no third party right.
as my client, well, let them take an action.
Please come back. Let him take instruction. In the meantime, please come.
Officers as well, let it that protection may be given. At least no else should operate it.
With regard to the security, we have said.
No, security. Now kindly see, my lord, their intention is if that be so.
With regard to that matter, I need to take instructions, but we'll.
Then in that case, in that case, my lord, let it appear next week, my lord. Because if they come up with any tender.
Not possible, please come back. Next matter.
Time for the petition. The petitioner has challenged the resolution adopted by the.
I'm declaring on behalf of the private respondents.
Petitioner has challenged the resolution adopted by the State Transport Authority, West Bengal, my lord.
Mr. Khan for the private respondents?
There are 15 private respondents. He is appearing for the 7, my lord. And all other were served, my lord.
Yes, that's record.
Yes.
Yes, that's record. Yes.
13, 16, 17.
Yes, ma'am. The petitioner has challenged the resolution of the State Transport Authority whereby the grant was made in favor of the.
I'm appealing.
Yes, ma'am. And the earlier occasion, my lord was pleased to observe that the existing operator, because the petitioner is an existing operator, whether he has any right to challenge the resolution whereby the grant was made in favor of the other operators, my lord. And the preliminary objection was raised by the state authority, my lord, learned advocate for the state authority regarding the maintainability of the writ petition. They relied on one judgment, that is Mithilesh Garg judgment, that is reported in 1992 Supreme Court, my lord, page 443. And this is the judgment. And by this judgment, my lord, there was an observation of the Supreme Court that the existing operator has no right to raise any objection against the new grant of permit because the 88 Act, it based on the liberalized policy whereby any person can be granted permit because the grant of permit is a policy. And
Relevant paragraph?
yes, my lord. Not you kindly come to paragraph 5.
Well, I have also preliminary objection that it is not maintainable.
I shall satisfy.
So let us hear Mr. Khan first.
Yes, it will be better for me.
He is challenging the maintainability. He has the first right of audience.
Yes.
In earlier occasion, he said that the existing operator, he has no right to raise any objection. That is the preliminary.
And he has referred to this judgment.
It was referred by
That is
Mr. Devray.
Mr. Khan?
Yes. Yes.
That is all your submission with regard to maintainability.
Yes, regarding maintainability. Well, petitioner is the existing operator on the road. Kindly see the page number 32. Route is Dhulaguri to Alia University. Well, this entire route is covered by two regions.
Page number 92.
32. 32.
Yes.
But the route is covered by two regions. Marod has got it. Dhulaguri to Alia University. Via Onkarhati, Hapragachi, Belpol, Vidyasagar Setu, Hastings, Exide, Minto Park, Park Circus, 4 numbers, Science City, Nico Park, Sector 5, Newtown, Unitec, and Equespace. And this is the entire alignment. Here in this case, the petitioner has stated in the writ petition that he is the valid permit holder and operating highway on the entire route. The route is covered by two regions. And according to section 88 of the Motor Vehicles Act, if the route is covered more than two regions, unless the permit is consigned by the other regions, the permit will not be valid to the other regions. But he stated here on oath that he is operating the vehicle on the entire alignment field without counter signature. Now, can you see the page number 34? In counter signature portion,
page number?
Page number 34. The continuation, these are part A of the permit. Continuation, counter signature.
It's blank.
Blank. That means they cannot say that I am valid permit holder. Not only this, in the state he is the bona fide operator. So, my lord, on the sale same issue. On the sale same issue, a writ petition was moved before the Honorable Court. That the petitioner was on route number 56 from Howrah station to Sodhpur. We are operating without counter signature. Now, I appear on behalf of the private respondents. Your allegation against the private respondents that the permit was issued by the same authority, that is Regional Transport Authority Howrah, from Howrah Park Service Station to Sodhpur via self-enroll without counter signature. Then I took this point. Then this one of his Lordship Honorable Justice Shandar was pleased to hold that the writ petition has been moved under Article High Priority Constitutional Revision Article 226. That each and every person should have come to the court with a clean hand, honesty, and transparency, and only relevant records documents are required for the consideration of this matter. So he has not come with a clean hand. Not only this, it is perfectly evident, in the pleading itself, that he stated that he is a valid permit holder, and also he is the bona fide permit holder stated in the pleadings. But ultimately, it is said that he himself flying the vehicle illegally without any counter. Now, their allegation also against our counter. I am placing this judgment. I am placing the judgment.
Yes, paragraph.
Now, just my starting alone, it will be better for this lordship understanding. And page number 4 to 9.
Yes.
Starting my lord, the read petition has been filed by two petitioners who have stated in paragraph 2 of the read petition that they are operators in respect of route number 56 from Howrah station to Titagarh as extended up to Ruia via Badaghat, Husli, Belur, Dakshineshwar, Dunlop, Shodhpur, etc. The reason for approaching this court, according to the petitioner, is that the concerned authorities are on the verge of issuing permit in favor of the private respondent in respect of a non-formulated route from Howrah Fire Service Station to Shodhpur in contravention to the previous of the Motor Vehicles Act 1908 as well as the rules framed thereunder. A report in the form of affidavit was called for, which has since been filed by the original Transport Authority Howrah. Learned advocate appearing on behalf of the private respondent draws this court attention to the interdictive permit issued in favor of the petitioner by the Secretary RTA Howrah, which does not have any signature of endorsement of the other regional transport authority, namely North 24 Prognas, whose jurisdiction route number 56 terminates. In response to the learned advocate for the petitioner submits that merely because the permit does not have the counter signature of the other regional transport authority, it does not mean that the petitioners are not allowed to fly within the region of the regional transport authority Howrah up to the point falling within the jurisdiction, even though the permit is for interregional route. While it is true that a person in whose favor an interregional permit issued is entitled to operate along with the designated route up to the limit of jurisdiction of the concerned regional transport authority who has signed the permit, here it is a case of making statements on both, which is patently false. In paragraph 2 of the read petition, it has been specifically stated by the petitioner that they are operators in respect of number 56, that is from Howrah station to Titagarh, as extended up to Ruia via Badaghat, Husuri, Belur, Dakshineshwar, Dunlop, Shodhpur, etc. The submission made by the learned advocate for the petitioner, however, is wholly contrary to the pleadings contained under paragraph 2 of the read petition. Next paragraph. If a person seeks to invoke this court high priority constitutional jurisdiction under Article 226 of the Constitution of India, which is essentially discretionary jurisdiction, he has to approach this court with clean hands and with utter honesty and transparency, which will manifest itself from the pleading itself, wherein only material facts are required to be stated. The Supreme Court is at least 3 judgments has categorically observed to the effect that the jurisdiction of the High Court under Article 226 of the Constitution of India is extraordinary, equitable, and discretionary, and it is imperative that a person, while approaching the read court, must come with clean hands and put forward the relevant material facts before the court without conceding or suppressing anything, and only then seek an appropriate relief. If there is no candidate disclosure of relevant and material facts of the petitioner is guilty of misleading the court, his or her petition may be dismissed at the threshold without even considering the merits of the claim. In this context, one may take notice of the judgment rendered by the Supreme Court in 3 judgments, one place in judgment. 7. It is publicly evident that not only the petitioner have not disclosed all material facts clearly and truly, but have stated them in a distorted manner in order to mislead the court. The impression which the court gets from paragraph 2 of the petition is that the petitioners have a valid permit to fly on route number 56, which covers 2 regions, that is Howrah and North 24 Prognas. The document annexed to the read petition, however, revealed that the petitioners have not clearance from only one authority, namely the Regional Transport Authority Howrah, and not from the Regional Transport Authority North 24 Prognas. This fact has not been stated anywhere in the pleading. In such a factual scenario, the read petitioner ought to have come with candid facts and made a clean breast of all material details, in the absence of which the read petitioners are not permitted to hold the read of the court with 12 hands. Suppression of material facts is not an advocacy, it is a jugglery, manipulation, maneuvering, or is misrepresentation, which has no place in equitable and prerogative jurisdiction. In this context, one may take notice of the ratio of the decision rendered by the King's Bench in the Southern Circuit. Next, my lord, it is noticed from the facts of the instant case that the petitioners are essentially seeking to try and render the process initiated by the Regional Transport Authority Howrah to grant permits in favor of the private respondents nugatory. The report in the form of an affidavit reveals that the Regional Transport Authority Howrah is merely acting in terms of an order of this court dated 13 May 2016, first in another writ proceeding. The manner in which the petitioners have approached this court makes their bona fide suspect. Although in paragraph 40 of the instant writ petition, the following statement has been made: this application is made bona fide and for the ends of justice and equity and fairness. A person who approaches this court invoking high prerogative constitutional jurisdiction under Article 226 of the Constitution of India essentially seeks relief which is discretionary in nature. For such discretionary relief to be granted, the petitioner has to demonstrate an impeachable bona fide. This is precisely why the petitioner appears to make in his or her petition specific averment to the effect that the application is made bona fide and for the ends of justice. In this context, one may take notice of the observation made at his court, there cannot be any manner of doubt whatsoever that the facts of the circumstances of instant case, the writ petition was not made bona fide, even though the petitioners have made statements to that effect in paragraph 40 of the petition. The writ is therefore liable to be dismissed with cause and accordingly dismissed with cause SS on the same identical case.
That's all your submission on
This is
maintenance.
on the maintainable point. So the merit.
Yes, let the petitioner respond to this.
Now the question is that, my lord, whether my route falls within the region of 2 or not. That is the primary preliminary objection raised by Mr. Khan, my lord. Lordship, let us come to the route of the petitioner, writ petitioner. That is from Dhulagori to Alia University. Now, it was issued by the Regional Transport Authority, Kolkata, my lord. It was not issued by the Regional Transport Authority, Howrah. So whether Regional Transport Authority, Kolkata has the jurisdiction to issue permit in respect of the entire route or not, that is the question, my lord. Now, my lord, the jurisdiction of Regional Transport Authority, Kolkata, that has to be ascertained, and what will be the periphery of that jurisdiction, my lord. Lordship, kindly come to page 45 of my writ application. Annexure P4. Initially, my lord, Regional Transport Authority, Kolkata has a particular jurisdiction which was subsequently extended in the year 2016, my lord. If I use the notification, and the type copy is at page 46A, my lord. I have annexed the true copy. I am placing the same. Involving public transport in Kolkata and adjoining urban agglomeration, artificial barriers among the different authorities in greater metropolitan transport planning and consequent lack of ease in delivery of public service in transport sector has been critical examination by the state government in transport department in the recent past. Regional Transport Authority, that is RTA Kolkata, has also taken stock on the situation, has proposed for inclusion of adjoining urban areas within the jurisdiction for the purpose of administering route and permit related activities in unified manner. Upon careful examination of the matter and consideration of various aspects thereof, and in exercise of power conferred under section 68(1) of the Motor Vehicles Act 1988, read with Rule 83(1) of the West Bengal Motor Vehicles Rules 1989, the governor has been pleased to declare that the jurisdiction of RTA Kolkata will be expanded and comprised with immediate effect of the combined areas of the Police Commissionerate of Kolkata, Howrah, Barakpur, and Bidhannagar in the manner and for the purpose of stated hereunder, my lord. So, my lord, Regional Transport Authority, Kolkata's jurisdiction has been extended to the area of Police Commissionerate of this particular 4 region, my lord: Kolkata, Howrah, Barakpur, and Bidhannagar. And in terms of that, my lord, the RTA South Chobis, there are other aspects, my lord, but these police commissionerate has come within the jurisdiction of RTA Kolkata. So in terms of that, my lord, this particular route, that is Alia University to Dhulagori and Onkurhati, Santragachi, all are within the police commissionerate of these 4 particular. Yes, my no, not necessarily Howrah, my lord. These are within the Howrah, and thereafter Kolkata, and thereafter, my lord, Bidhannagar and Barakpur, within the 4 particular police commissioner jurisdiction. So, my lord, the entire alignment is within the Regional Transport Authority, Kolkata. So, no counter signature is required, my lord. And that is why the Regional Transport Authority in their board meeting issued this. And if your lordship so pleases, I shall produce the notification by which this particular route was notified under section 68(3)(c)(8). That particular, my lord, I have given the notification number.
Indication.
Yes, well, I have given the number. Lordship, kindly come to page 5, paragraph 3. The petitioner states that the said route is formulated by the Transport Department, Government of West Bengal under section 68(3)(CA of the Motor Vehicles Act 1988. The number of the permit in the route in question is also fixed as 20 according to section 71(3) of the Motor Vehicles Act 1988. Wide notification number RTA/bus/1495 dated 27 January 2021. So, my lord, this particular, if your lordship so pleases, I shall produce the notification. So, if it is formulated by the Transport Department, Government of West Bengal, and accordingly the permit was issued by the Regional Transport Authority, Kolkata, my lord, so no counter signature is necessary because it falls within the zone of entire RTA
Same
Kolkata.
RTA.
Yes, my lord. Yes, this is my.
Yes, so now on merits.
Yes.
My lord, so far my lord, according to section 68(3)(CA, route to be formulated by the state government for state carriage permit. Now, state and route permit has been formulated. Or if the route is formulated after formulation of the road, then my lord, who is the original registered permission authority? Application made according to section 69. Application made to the region where the major portion falls. So here in this case, major portion falls in Kolkata and route notification and also my lord, state government, my lord, the formulated the route under section 63(3)(CA and declaring that the regional transport authority, Kolkata region, will be the permit issuing authority. That does not mean if the permit is issued under two regions.
RTA,
Yes,
Kolkata has
here in this case, this is my answer is this. My lord, number of population has been increased day by day. Not only this, area of the Kolkata, my lord, extend.
You are not disputing this notification, isn't it?
No, they are not disputed because what is the language of this clause that the after extension of the Kolkata, Vidhannagar, Municipal and Howrah, that means that if any major portion falls within Kolkata or Howrah, the application will transfer after this notification. If it is found that the major portion falls within the Kolkata Municipal Corporation, to the other region. That does not mean that the permit vehicle will be fly on the other without according to section 68. The permit will not be other region.
I think the interpretation is little, it's not correct.
2016, this notification was issued and my permit was granted in 2022, my lord.
The RTA of the Southwest North Howrah and North will transfer all such routes. This notification was issued in the year 2016.
Yes. And the permit is
transfer, all the routes are transferred, all the permit was issued. Suppose, my lord, after extension of the Calcutta region, the permit, before that, permit was issued by the RTA Kolkata or Howrah. After notification is found, the major portion falls on the selection road on that region. So that other region, my lord, is responsibility to transfer all the documents to another region. Here in this, after that, application was made to this notification. Yes.
It was issued by RTA Kolkata in 2022.
Yes.
According to the 2016 notification, RTA Kolkata's jurisdiction was extended to the police commissionerate areas of
Police commissionerate of Howrah means that does mean Howrah means Howrah Municipal Corporation or what is the portion of the Howrah not inter Howrah district.
So the police commissionerate area of Howrah and other places.
Up to the police commissioner up to Dhulagor or Uluveri. That is what the document required instruction required my land.
Yes, Mr. Devra.
Up to Satragachi. Police commissioner.
Just within Satragachi.
Apni instruction.
It is within the police commissionerate jurisdiction of Howrah.
Dhulagor within the municipal.
Come back, because the 2016 notification my that has been probably, I think,
recalled
by this authority. Because there are some difficulty arising, because some portion of the some buses or minibuses operating from Alipur or Barasat or TS1, they are tremendous trouble for renewing or granting permit. That is why government again further notified that 2018 subsequent
Will you come back with the
Yes, even better
notifications?
come. Because when the Dhulagad within the
Because the permit of 2024.
problem is solved.
After that, my notification I have to withdraw. That is,
And let Mr. Debra come back with the notifications.
Yes, will wait.
it is better, man. Other.
Better, yes.
And another thing, man, it is not under the commissionerate of.
Lordship,
Yeah,
kindly allow me 1 minute. Lordship, kindly come to rule 152.
You have a copy.
Yes, yes. Rule 152 of the West Bengal Motor Vehicles Board.
No, it's not.
Yes.
Permit granted by the Regional Transport Authority, Kolkata, in respect of stage carriage or contract carriage permit shall not require counter signature by the Regional Transport Authority, Howrah, for operation of such vehicle within the limits of Howrah Municipal Corporation or Bali.
The beyond Malot Dhulagad, Malot beyond Howrah, Bali.
That is within the police commissionerate.
Mr. Debra wants to come back.
Yes, it will.
What are the, what is the
This rule
area
is not
covered by
applicable.
Yes, yes.
The area covered, that has to be, otherwise.
Yeah, this is.
There is a not 24 corner.
Yes. Third learned counsels for the parties. Paragraph challenging the maintainability of the petition, comma, learned counsels for the private respondents who are represented submits that though permit was issued in favor of the petitioner for the route Dhulagori, Dhulagari, to Alia University, University by the Regional Transport Authority, Kolkata, the petitioner has been plying his vehicle illegally without the permit being countersigned by the RT Howrah. The petitioner has therefore not come before this court with clean hands and has suppressed relevant and material facts before the court, for which the writ petition ought to be dismissed. Stop. Learned Counsel has placed reliance on the authority in Obhijit Ghosh and another, ABHIJIT, and another versus the state of West Bengal and others, reported in 2017 within bracket 1 CLJ within bracket Cal 428 in support of his contention. Paragraph. Learned Counsel for the petitioner submits that V-Day notification issued by the Transport Department, Government of West Bengal on October 21, 2016, the jurisdiction of RTA Kolkata has been expanded to the police commissionerates of Kolkata, Howrah, Barakpur, and Bidhannagar. Stop. Therefore, counter signature of the petitioner's permit, which falls within the said jurisdiction, is not of the petitioner's permit, which falls within the said jurisdiction, within the said extended jurisdiction, is not required. Paragraph. Learned Counsel for the state respondents seeks to submit a report in the form of affidavit annexing relevant documents in this regard. Paragraph. Let the matter appear under the same heading on 14th May.
And they will not proceed with the offer letter, my lord.
Offer letter has been issued.
If the permit is granted, my lord, then the writ petition will ultimately become
No, it
infructuous.
will abide by the result of the.
Is that order there? It will abide by the resolution.
No, my lord.
No, the first time, first time.
Let there be such an, let there be such an order.
Yeah.
Any step taken by the authority in this, you have challenged the permits issued, isn't it?
No, my lord, I have challenged the offer letter. The offer letter starts from
In any step taken by the authority with regard to the offer letters issued in favor of the private respondents shall abide by the result of the requisition.
Bibliography.
matter will appear on 14th May.
14th.
Lord, I appear for the petitioner that this matter relates to the renewal of the permit, Madam Jane. Madam,
yes.
Lord, Lordship will kindly come to page 15. The petitioner is the holder of a permanent permit which was issued in the year 2024, and the said permit having been renewed from time to time remain valid. Right inside bottom 4/3/2024.
Yes.
Got it? It was issued in 2024 and since issued in the year 2024. 2004. Sorry, I stand corrected. In respect of the route Bajeshale to Bud 1, based on which permit has been, vehicle has been plying after renewal being effected from time to time, and the last renewal was made in 2019, right hand side bottom, up to 4/3/2024.
Yes.
Before expiry of the said permit, I approached the authorities for renewal of the permit. Page 55. 12th of February 2024, I approached the authorities based on which fees was collected by the authorities 4,540. The permit has not been renewed as yet. On 4th of March, I approached the authority, last day of the validity of the permit, I approached the authorities to renew the permit. It was not done. The backdrop of the case is that this route is Bajisalepur to Bud 1 comes under the exceptional clause of the notification, and the petitioner moved the writ petition assailing the order passed by the DM, by which his prayer for flying of the vehicle through Burdwan town was rejected. And in the said petition, an interim order has been passed by your lordship, which has been existing till today.
But your permit has expired.
Permit has expired, but they have withheld the renewal of the permit because of this reason.
The matter needs to be heard.
Your lordship kindly listen. No, your lordship kindly see. Your lordship kindly see. Your lordship kindly see section 81 for a moment, under which circumstances they can reject the application for renewal.
They have not rejected.
And because please sono na bhai. But 81 of the Motor Vehicles Act clearly speaks 81(4). There are 4 contingencies where they can reject the application. Yes. But none of the contingencies applies in my case. A, financial condition of the applicant is evidenced by insolvency. It is not applied. The applicant had been punished twice more for any of the following offences. Offences within 12 months reckoned from 15 days prior to the date of consideration of the application. The clause is without payment of tax, without payment of due tax, and without payment of tax during the grace period, any plying of vehicle on unauthorized route, making unauthorized trip. None of the clauses are applies here. And they have accepted the renewal fees, and they have withheld the permit because I have challenged the decision of the district magistrate Barwan, wherein
they will be on this making unauthorized trips.
Lord, it can't be. When your lordship has been pleased to pass an interim order permitting me to ply the vehicle.
till validity.
I'm making submission on that. That petition is today, your lordship passed the order interim order. It was in the list. But because of the jugglery taken by the authorities, I have been prevented from applying my vehicle unless my permit is renewed. And 2081.
Let your permit remain as it is.
Your lordship kindly see 81.5 for a moment. Where a permit has been renewed under this section after the expiry of the period thereof, such renewal shall have effect from the date of such expiry, irrespective of whether or not a temporary permit has been granted under clause D. My submission that I have complied with the formalities advised in the Act itself. They have accepted the fees, but they have intentionally withheld renewal of the permit in order to prevent me from plying the vehicle on the route. Unless, and in other case, your lordship is pleased to pass an interim order that I may be permitted to ply the vehicle during validity of the permit. But under this juncture, but if your lordship would not pass any order to renew the permit, then my vehicle will remain idle and the other petition will be made to be infructuous.
The court cannot direct renewal of permit. The court can only direct consideration for renewal.
Very well, my lord. Your lordship direct them.
If I direct that, what the result is also very obvious. It will be dismissed on the ground that the issue is pending before this court.
Very well.
So why don't
very well let them take a decision, because my plying of the vehicle will be stopped. I will be suffering. Let them take a decision in terms of section 81.
It will be more prudent if you wait for some time. Let the other issue be decided by this court. That will solve your problem also. Because now if I direct the authority to consider, the obvious result is it will be dismissed. You must understand.
But they are.
That will not endure to your benefit.
In any event, they could not go beyond the provisions of section 81. So for renewal,
they'll say you are not covered by the exception and it will be dismissed. Simple.
No, that issue is pending before lordship. Exception whether my
Paper will agree with me. If I give a direction for consideration, the only result is dismissal.
Nothing.
So without that, let it remain. Let us decide the earlier issue, which is the parent issue. Your permit will be automatically renewed if the other issues are decided in your favor. And if not, it cannot be renewed. Simple.
But if I fail, question would be otherwise. But if I succeed,
no, your permit will be retroactive.
Let us wait to see that you succeed in the other petitions.
In view of section 81 subsection 5, if I succeed, then my permit would be renewed. But in the meantime, my flying will be stopped. Although
that can't be helped.
Your lordship kindly take this. Is a running vehicle, my lord. It is a flying.
Understand, but
who will suffer? Then passenger will suffer. Passenger will suffer, and I will be deprived of.
I had granted the leverage of flying the vehicle till validity of the permit.
Yes,
in
I
all
understand.
The cases. But now, since in this case the permit has expired, I cannot extend it unless the issue is decided.
Lord,
because the issue is under consideration.
May I approach this? Lord,
it's a contradictory approach by the court itself. On one hand, I say that the
very well, issue is, but in that event, and
again I ask the authority to
in that event, may I pray this, Lord, subject to lordship consideration, let the authority take a decision regarding renewal of the permit in terms of section 81. Because renewal is covered under section. Since I have made the application, they have accepted the fees. It is not that
this will not help. This will not help. I'll grant you an adjournment, a little long adjournment, so that before that we can decide the parent issue. I cannot direct the authority to issue in terms of section 81 when the parent issue is pending.
But under the they are certainly bound to take the decision regarding the renewal of the permit in terms of section 81. They are bound to take the decision. They cannot withhold it.
So if you are happy with that, let me direct the authority to take a decision.
In terms of section 81, because renewal is covered under their provisions, let them take it.
According to law. So let them decide.
Your lordship specify the section.
According to law, along with the order passed by you.
Why?
Any order passed by
why? I have been
If I don't say that, it will be taken into consideration. Affidavit of service. You're inviting a rejection, that's all, nothing else.
Another
another
Well,
litigation.
very well, let the matter be adjourned. Let the matter be adjourned.
Mr. You must understand.
Very
You're
well.
inviting a rejection.
Very well, very well.
If the other matters are decided in your favor, the authority has to renew. If they are not decided in your favor, you are not eligible for a renewal. Simple.
Yes, if I fail, then I am not
Absolutely. So
entitled.
this will be guided by the result of the other writ petitions. Affidavit of service by learned counsels for the parties. Let it appear in the monthly list of June. In the meantime, I hope to dispose of the other matters.
Yes.
You can mention after that.
It will be solved after 15th of it will be solved.
Let the matter appear under the same heading in the monthly list of June 2024. Let
Yes.
us-